for correction, name, spelling.
Yes.
Lordship, mentioning for correction, Lordship.
Yes, which correction you want?
Name of the advocate, or Anami Das, it's Oroni Das. It slipped.
Yes, Onami Das.
Anami Das is printed, it will be Oroni Das. Oroni Das.
We mentioned on Friday.
My lord, may I mention one matter?
Mention on Monday. She mentioned yesterday. I granted her leave. Mention on for correction. Mention on Monday. Yes.
For item number WPA.
Why you are mentioning? Today is not the mentioning date. Why you are mentioning?
My lord, for the delisting of the
Mention on Monday. Why you are mentioning? Yes, please call the list. Mention on Monday. She mentioned yesterday. I granted her leave. Yes.
There is urgency, my lord. Urgency.
Item number one.
Sorry,
please call the list. No.
Or
Item number one.
Or 13th of August, I have been asked to appear
Yes,
before the authority. My lord.
No
kindly
further mentioning is. Please call the list.
I am for the item number one. My lord, for once, when it comes to the last order passed by my lord, pleasure was to direct the state to file a report.
My lord, you are ready with the report, my lord.
To the disclosure as to the progress made in the investigation.
My lord, we are in receipt of 3 reports,
Just
different police stations.
in this one. When the interim order was passed initially?
My lord, the interim order was passed on 4th September 2024.
24.
Yes. My lord, there are 15 numbers of respondents. Out of 15 respondents, my lord, I find only 4, 5, 6, 8, 9, 10. They have used an opposition. And rest, my lord, they haven't as on date. Subject to correct.
Yes. Report.
My lord, you have received 3 reports.
Have you filed charge sheet?
My lord. In Chatterjee Hat police station, the charge sheet have been filed.
My lord, may I get a copy of the report?
This is a copy of the FIR, my lord.
I have not called for a copy of FIR. I have called for a report disclosing present status of the investigation. Yes, what are the instructions with regard to status?
My lord, the investigation is on. They are carrying out the investigations.
Yes.
And the investigation is on, and their peace and tranquility has been maintained. So they are going to come up with this report.
Investigation is going on and
peace has been maintained there for the time.
Peace
Peace and tranquility.
There cannot be any big.
Please, Justin. Now, how many cases, how many criminal prosecutions are there? Shibpur police station is two.
Shibpur, my lord, in Shibpur position, there are two criminal prosecutions. And in
Mr. Jana, how many?
My lord,
criminal prosecutions
there are altogether, my lord, one is lying at Shibpur police station. Other one is Chatterjee police
Yes,
station.
one is Chatterjee
Jogasa,
case number 169 of 2024.
Yes.
And apart from 169 2024, other what are
My
the
lord,
other
before
prosecutions?
Jogacha police station, New Market police station, Netaji Nagar police station, Moidan police station, Jorasago police station, and Hia Street police stations.
In connection with in Chatterjee PS case number 169 2024,
My lord, not in
1st
connection.
of August, here this court, 1st of August charge sheet has been filed.
In connection with Chatterjee.
Yes.
Yes, my lord. So for the other police stations,
For other cases, what is the what are the present situation?
in Shibpur, my lord,
What is the present situation
completion
relating to
of
the
the
status of investigation?
there's a in Shibpur, my lord, the completion of investigation under PS case number 373 of 2024 was charge sheeted. The charge sheet number 377 of 31/7/2025 on the relevant provisions of law. Sri Bhaskar Ghosh and
See,
others.
prepare a chart.
My lord.
Prepare a chart.
My lord.
See, for example, if there are 6 criminal cases pending against the petitioner, now in a chart indicate that in which cases charge sheets have been filed, in which cases investigation is going on.
My lord.
Otherwise, it is very difficult for
My
this
lord,
court
prepare
to
a chart.
comprehend.
My lord. I will give it by tomorrow.
Okay, prepare a tabular in a tabular form, indicate the case numbers and where charges have been filed against that particular case. Incorporate this the charge sheet on so and so date, charge sheet number so and so filed, and in some of the cases, if investigations are yet to complete, in that event indicate that and the status of the investigation.
My lord.
my lord, may I get a copy
Issue.
of the report? My lord,
No, this is for this court, not for you. In terms of the order dated 29 July 2026, matter is taken up for consideration when learned advocate representing state respondents has filed communications, 3 communications. One is dated 11th August 2026 of Inspector in Charge, Jogacha Police Station, Howrah, comma. Second one is dated 10th August 2026, prepared by Inspector in Charge, Shibpur Police Station, Howrah. And another communication is dated 10th August 2026 of Inspector in Charge, Chatterjee Police Station, Howrah, comma, same are taken on record. Next paragraph, learned advocate, concerned respondent authority, concerned police authority directed to prepare a chart indicating criminal prosecutions which are pending against the petitioner as on date and present status of those prosecutions by fortnight from date. Stop. Next paragraph, list the matter under the same heading. List the matter under the same heading on September 2026. Stop. Interim order passed on, next paragraph, interim order passed on 4th September 2024 is extended till 30th September 2026.
Extremely
or until further order, whichever is earlier.
extremely
Take, copy of FIR. That is not required.
Great.
Learned advocate for the petitioner is directed to communicate this order to the concerned police authorities for compliance.
I see.
By 17th August 2026 and file affidavit of service on the next date.
I'm great.
Next.
Item number 2.
Wait, please, Manoj.
May it please your lordship, my lord. It appear on behalf of the state respondent. Being led by ASG Raju sir, my lord, who is online.
Yes. Now, Mr. Shankar Narayan,
Yes, but
Yes.
you want to make further submission?
Well, I don't think I really need to respond to anything.
Anything left?
I don't think there is much left, Manoj.
My perception,
I've
having
already
heard
half of my
your last
submission,
occasion,
Yes, Manoj. I
having
don't want to
heard
take
you
more
on
of the.
last occasion. That
Yes,
was
Manoj.
on 30th July 2026.
Correct.
No, I've
On
not
30th July.
completed, man. I've
I
not
don't
completed.
want to take more of the court's time on this. I just have submitted that note, my lord. That may be with your lordships. On the last occasion itself. That
Yes.
note had been
Yes.
submitted.
Yes, that
Yes,
was filed. It was lying with the record.
Yes.
We have
And
not
I
been, my
want to
lord, handed over
confirm-
with a copy of the note, my lord.
Yes.
In the event, my lord, we need to.
No, it's not a written notes. It is for the consumption
Very-
of the court.
very-
Yes.
And Manoj, I want to once again
Madam, may I
confirm that
continue?
the
Yes, Mr.
respondents have
Shankar.
handed up an updated list of the FIRs which
Yes.
has been received by us. There are 16
Oh.
FIRs. You have taken note of that on the last occasion, Manoj. I'm grateful.
Yes, that is in a tabular form. This was filed.
Yes,
But
yes,
we have
I've-
handed up
I've
the
been
list,
told
my lord, to them.
There's a revised, more detailed
Just
list.
a
which
minute.
is-
Just a minute. Let me find it out. Yes, I remember.
That 16, you have noted it in your last order, Manoj, of 6th August. Para 6 of the last order.
I'm giving another copy, my lord. I'm giving.
Just a minute. That copy is there. Yes, this one.
No, my learned senior is talking about that
This is the
FIR which has been supplied by them.
Manoj will recall the direction of the
no.
court.
In
was-
this chart, there are 11.
Yes.
There are 11.
Yes. Now, that was based on a surmise about what the actual complaints and FIRs were, Manoj.
Now,
Your lordships-
subsequently, in terms of the order passed on the last occasion, they
Correct.
compared with this
Yes.
direction and the chart was given.
Correct. And you have taken note of it in your last order of 6th August 2026 at para 6.
This is the chart, Mr. Nondi.
No, my lord. My lord, this one.
My lord, I have handed them, my lord, a single page, my lord, on the last occasion containing the details of the FIR.
Just give it. Find it.
I have a chart, my lord. I can.
Out of this 16 FIRs, one is Bidhannagar police station case number 75. So far, I remember.
Segment of this petition.
That is already questioned and petitioner is enjoying an interim order.
My lord. Pursuant to
Now,
lordship's order.
apart from this, all 15s are not disclosed at the time of filing of this writ petition. So far, I have learned
That is correct.
representing the
correct.
petitioner.
That
Now,
is correct.
probably five criminal prosecutions were disclosed in the writ petition, out
Yes.
of which three particulars of three criminal prosecutions were disclosed and matter was heard. Subsequently,
Yes.
chart was provided giving
Yes.
details of 16 FIRs.
My lord.
Now,
Yes,
so far the present matter is concerned, excluding because there is no further order need be passed on
Yes.
Bidhannagar Cybercrime Police Station FIR number 75 because
Yes.
there another writ petition is pending.
Yes.
So far the second another criminal revisional application is pending where petitioner is enjoying an interim protection. Which one is that matter?
He has challenged,
Just a minute.
not
Which one is that matter?
My lord, will kindly peruse page
That
13
is-
of the writ
No,
that
from
is-
the chart. That will be helpful.
That is Hare Street, my lord.
Yes.
That is Hare Street. Yes, that is just.
Here he has challenged, my lord, Bhavanipur, not Bidhannagar, my lord. He has challenged Bhavanipur.
So within 16, Hare Street is not there.
No, no. Even Bidhannagar is
But
not there.
Hare Street, my lord, it's a different application. Pursuant to that, we have filed a CRR.
Yes.
That is
So
pending.
that prosecution is not disclosed out of 16 in this
No,
chart of
13,
16.
item number 13.
13. Just. Yes. Yes. So 13 and 14, no order no order is required. Petitioner is already enjoying interim protection. So rest of the 14 matters, you are seeking order. Yes.
But I'm being led by.
Another writ is also pending in your lordship's list.
That's item 83, my lords.
There are also some of the matters.
Some of the matters.
Some of the prosecutions.
My update-
So in this writ petition, court
Three.
is
Only
then
three.
Mr. Shankar Narayanan, in this writ petition, court is confining itself to 3.
Yes.
That's correct. That's correct. And you've made note of it, my lords, in your order
Yes.
of 30th July. You've mentioned
Order-
the 3.
Order which will be passed in this writ petition, that will be considered in a subsequent writ petition file challenging other
That's
prosecutions.
correct. I'm grateful. That's
Yes.
Yes, but I'm being
Yes,
led
Mr.
by.
Raju.
Yes, my lord. May I point out, my lord?
Yes. Very precisely, I have heard you extensively on last occasion.
Yes, I'll be
Yes.
very precise. The only thing, my lord, my
Yes.
first submission is that if an FIR discloses a cognizable offense,
And court, Mr. Shankar Narayanan, court wants to see the order passed yesterday by the Honorable Supreme Court
Yes,
with regard to treatment of the petitioner.
correct. That I'll send a copy.
Order.
It's not been
Till that-
uploaded. From what I understand, my lords, it's not been uploaded yet. The minute it's
Very well.
uploaded, we'll make sure. Your
Very well.
lords.
Then you instruct your junior to file that order.
We'll make sure. We'll make sure.
that order was pertaining to his traveling abroad, my lords. Permission seeking travel abroad, my lord. That was the prayer in that petition, where he was already granted bail. There were certain conditions which required to be modified. That was what was heard yesterday. Now, as far as the present matters are concerned, my first submission is this, my lords. If a FIR discloses a cognizable offense, it cannot be quashed. At the threshold, the investigation is pending. We are at the nascent stage of investigation.
This argument was made on the last occasion.
Yes,
If any new thing you want to add, please add it.
Therefore, I'm pointing out from the FIRs how a cognizable offense is made out.
Yes. These are the points taken, argued, heard by this court.
Yes.
Any new point, if you want to urge, please urge it, Mr. Raju.
Now, kindly look, I'm now arguing on facts, how the offenses are made out.
Ah.
This I never argue. Now look at each of the FIRs, my lord. The FIRs. First is Bishnupur Police Station 668.
When it was filed, Mr. Raju, this complaint,
Complaint was filed on 13 June 26.
all are post declaration of result.
Yes.
So on this premise, also already court has passed an order on 21st of May permitting the granting the petitioner interim protection. So the complaints which are lodged after declaration of result on 4th of May 2026, that will be considered, but no custodial interrogation. Court will have already has considered similar issue in FIR 75 of 2026.
I'm obliged, my lord. My lords may kindly appreciate. The
Yes.
prayer is for quashing. The prayer is not for anticipatory bail.
Yes.
When custodial interrogation assumes some significance. In a prayer for quashing, custodial interrogation would, according to my submission, would not be relevant, because prayer is not that I should be granted bail, anticipatory bail. It is only when anticipatory bail.
Show me any FIR or complaint prior to 4th of May 2026.
There,
I want to hear you on this issue first.
there is no fourth of, there is no
Yes.
prior to, my lords are right. All are
Yes.
subsequent to poll results.
Yes, all are post
All
declaration
all
of
three are-
assembly election of 2026. So this will be considered as it was decided in a previous matter at the interim stage on 21st of May.
So may I take it that what the court is considering is that no custodial interrogation in the quashing petitions will not be allowed. Is that what is being contemplated, so that I may formulate my arguments in those lines? If the proceedings are going to be quashed, there's no question of custodial interrogation.
No,
But-
no, court is not going to quash it. You continue with the investigation. And I will direct and ensure that the petitioner will cooperate with the investigation. But don't take any coercive steps in the meantime.
Now kindly have a look at the prayers. Kindly have a look at the prayers.
Today, court is not passing a final order quashing the proceedings.
My lord, sir,
You investigate the case, submit a report, but don't take any coercive steps. As already this court has passed an order on 21st of May 2026, granting the petitioner interim protection.
may I only point out this, my lords? If the my lords, then the
Now,
petition.
Mr. Raju, if today court refused to or declines to grant interim protection to the petitioner, then the protection which was granted in connection with FIR number 75 of Bidhannagar Cybercrime Police Station case, that will be that order will be nugatory.
My submission is this, my lord.
Yes.
My submission is that the petition itself requires to be dismissed. If the
Yes.
petition itself requires to be dismissed, there is no question of granting any interim relief. That's my
Yes.
first submission. And there are reasons which which were submitted earlier on the earlier date, why the petitions are required to be dismissed. Now, therefore, if the FIR makes out a cognizable offense, there is no question of quashing the FIR. He doesn't, his petition is not even argued that the offense is not made out. As far as I know, no submission was made that the FIRs do not disclose a cognizable offense. That submission was not made. That is not his case.
It is my case. I specifically took each FIR and I said there's no offense made out. Forget about cognizable.
You never argued. I am sorry, you never argued this point. You never argued it. You never argued. You never formulated this point. You never elaborated on this point.
Elaborated, maybe not. Yes.
No, you did not argue, sir. You never argued this point. And he never argued. I said on the last date also, he never argued that no offense.
If FIR discloses cognizable offense, in that event you investigate the case.
That event I will, of course I will. I am
You
duty bound to
investigate
investigate.
case,
In
and
the-
court is not passing an order, thereby restraining the investigating agency from investigating the case. But thing is this, that petitioner has to cooperate. And if that cooperation is ensured by the delivery of the order which is to be passed by this court, then where is the difficulty?
I am not clear. I'm sorry, my lord, I'm not clear.
Yes.
Intention is, if the offense is disclosed, then the quashing petition does not survive. If the quashing petition does not survive, there is no question of granting him any interim relief. And if at all he wants any interim relief in the nature of no coercive steps, or in the nature of giving him anticipatory bail, or in the nature of not custodial interrogation, he will have to file an anticipatory bail application. This is not the petition.
Yes, Mr. Raju, point noted. Any other point?
Yes, there are several points. Therefore, let me now take my lord to the FIRs, which were contents of which were not read when it was argued, to show that offense, cognizable offense is not made out. My specific cases, each of these FIRs make out a cognizable offense. Now kindly look at the FIRs and look at the cognizable offenses which are made out, my lords.
With regard to FIR, detailed submission was made, Mr. Raju.
That no,
Detailed submission was, I have heard you last occasion. Any
not on
action or
facts,
alteration,
not on facts.
that
I
is
said,
considered. With regard to FIR, FIRs were placed, matter was heard in detail.
When I ended my submissions, I said I
Yes.
have.
Now I will
facts
not
of-
permit you to open the case again. No, I have heard you more than 1 hour.
With respect, but I have not opened as far as the FIRs are concerned. The
Yes,
facts
yes, yes. There's a
Yes.
detailed submission made. Only if anything is left, now I will not permit you to open the case again. No.
I'm not opening the case. I will not argue, which I did not
Yes.
argue on the earlier occasion. I am arguing only this, that the FIR disclosed a cognizable offense. Now let me point out the facts in the FIR which disclose a cognizable offense. What was argued by the other side was there is a delay. What was argued was mala fights. It was never argued that there is a cognizable offense is not
Yes,
disclosed.
yes. Very well. Come to FIR.
Yes, my lords.
Which
Now-
FIR you want to rely upon?
প্রথমটা ভবানীপুর
FIR, my lords. Page 136 to 158 is a written complaint. In the other laptop. iPad.
Page
136 to 158.
It's a Kalitala case.
yes.
140 of 26. My lords have got it. It is a case pertaining to illicit mining. Get the page 136. Illicit mining operation in MLA Lake and in the adjoining critical wetland clusters located at Shankarpata main road. So
It is FIR dated 16 June 2026.
15,
Yes,
16 June 2026.
yes.
yes, my lord.
Kalidala Ashuti.
Mr. Raju, by whom this FIR was lodged?
By one Abhijit Das.
Who lost the election twice to the petitioner?
Maybe. Therefore,
And what are the period during which this alleged offense was committed?
but that, my lord, look at the FIR.
So whether these are not relevant considerations at the time of passing an interim order?
I am not saying about the, I am saying
Ah.
interim order can be passed. I am arguing the main, if the offense is not made
Very
out.
well.
if the
Today, Mr.
petition does
Raju, court is not hearing this matter on affidavit. So your main prayer of quashing will not be considered at this stage. Court is contemplating to pass an interim order and court will direct the parties to exchange affidavits. And court will permit the court will permit the investigating agency to investigate the case in accordance with law.
May I only point out this, my lords.
Yes.
For passing of an interim order, there must be prima facie case. You must, the first requirement is prima facie case. If my lords are not considering the main prayer, whether there's a prima facie case, then no interim relief can be granted with
Yes.
greatest respect. Prima facie, he must demonstrate a prima facie case.
So
And
let us see the outcome of the
Yes.
investigation. Let us see the outcome of the investigation.
Greatest respect, my lord, with greatest respect,
There is no charm in taking the petitioner into custody.
the cart before the
Let us
horse,
see
my
the
lord.
outcome of investigation.
This is not an anticipatory bail matter. This is a quashing matter. Therefore, you must
Yes,
first
yes.
make a
At
prima
least
facie
that
case
is,
for quashing.
at least this court is aware of this. Yes.
My lords may kindly have, he could have filed an anticipatory bail and prayed for no causes steps. He has come for quashing. If he has no case for quashing, where's the question of granting any interim relief? My submission is, he has absolutely no case as far as quashing is concerned. Matter may be filed, there may be a delay in filing. That is no ground for quashing if a cognizable offense is made out.
Yes, point noted. Any other point, Mr. Raju?
Now, I look at section 468 of the CRPC, which is new section is what?
Any other point, Mr. Raju?
This is offense punished with more than 3 years.
Yes.
Therefore, there is no limitation. Therefore, delay can't be a ground for quashing. Delay can't be a ground for quashing.
Yeah, that point was taken relying upon judgment. That there is no point of malafide or delay in the matter of in criminal jurisprudence.
Malafide is a different point. Malafide is a different point. My submission is this, that delay can't be a ground for quashing because unless it falls under the one of those provisions of 468, which is up to punishment with maximum 3 years imprisonment, delay can't be a ground for quashing. It may be a good ground for getting anticipatory bail. It definitely can't be a ground for quashing. So my submission is that mere delay in filing FIR can't be a ground of quashing. Delay has explained his part in power. Nobody would take the complaint. Therefore, my lords, delay in this particular case would though it is not relevant, would still be is explainable because his party was in power and nobody would register the FIR. Secondly, my lord, this is a case where national resources are plundered. This is a case of illicit mining and prima facie offences which are serious economic offences have been made out. Now kindly have a look, my lords. Kindly have a look at Tara Datta's case, my lord, 2000, volume 1, SCC 230, para 5 and 6. Punishment is more than 3 years. They can't be quashed on the ground of delay. It cannot be. That is what the legislature said. Ultimately, it is for the complainant to explain the delay. Therefore, delay merely because it is a 2017 incident filed in 2026 is no ground for quashing the complaint. That can never be a ground for quashing a complaint, my lord. If a cognizable offense is made out, the police are duty bound to register an FIR in view of Lalita Kumari's case, 2014.
These points will be considered at the time of final hearing of this writ petition. Today, court is at the motion stage, contemplating to pass an interim order.
But my lord, my
Court is
submission
not
is-
passing any order to impede the police authorities from investigating the case. So
contention is-
therefore, you go on with the investigation. Today, court is not passing any order in order to quash the proceedings. So there is a distinction with regard to the final order to be passed on the writ petition and the interim order which is court is contemplating to pass. So therefore, at this stage, court is not required to consider this. At the time of final hearing, court will consider these points whether it's a case of quashing or not.
May I point out, my lord, may I point out this, my lords? My lord, unless the petitioner makes out a case for quashing, there is no question of granting interim relief. Am I clear? My lord, I'm saying that unless he makes out a case for quashing, he is not entitled to interim relief.
That point I have taken, Mr. Raju. If any other point is there, please
Therefore,
agitate. I
he
have
has to
heard
make out
you.
a case.
Last
He
occasion,
cannot have a case
I have
for
heard
quashing.
you extensively.
And
And-
if, my lord, interim relief is granted without considering the fact that a prima facie case is made out or not, that would be amount to putting the cart before the horse. My first,
Yes,
he has
yes.
considered the
Yes.
prima case. He has
Yes,
not
I have-
prima
Yes.
facie case for quashing.
Yes,
That's
I
my
have
submission.
noted
Second,
your submission that if there is no prima facie
Yes,
case, then there is no case of there is no question of passing any interim protection. Yes. Any other point?
secondly, my lord, there are two judgments on which I am relying to show that the petition is not maintainable. Petition cannot be entertained because it doesn't make out a ground for quashing, then no interim relief can be granted. Two judgments of Supreme Court, Bharat Coking Coal 2011-14 SCC 140.
11-14.
No, problem is this, Mr. Raju, last occasion you have relied upon certain judgments.
Yes,
Now, in that event, again, I have to grant time to the petitioner to respond to these judgments. So
Yes,
only,
but-
no. For indefinite period, I will not go on
I
permit
did
this
not complain, but I did
proceedings
not
to go on.
submission.
So therefore, don't
complete my
rely
submission,
upon
my
any
lord.
judgments further. Whatever points you want to agitate, please agitate.
But-
And the final hearing is to be taken
Yes,
at the time of final hearing, you agitate these points.
but,
Because I have already heard Mr. Shankar Narayanan, you made an elaborate submission. If any addition or alteration, please don't open the case too wide so that I can again, this court needs to hear it again. That I will not permit.
my lords may say so, my lord. My lords may say so.
Yes.
My lords may say so that my lords may not permit me to argue further. That I don't want to argue, my lords. My lords may say so.
Yes.
My lords may say so that my lords are curtailing my submission. My lords may say so. Then there's nothing else for me to submit. Because I never completed my arguments. I'm not repeating my arguments. I'm not repeating the judgment.
I think it's very unfair, Mr. Raju. Please don't say that.
Don't interfere, Mr. Shankar Narayan.
Multiple opportunities have been given. You have taken an adjournment for the Solicitor General, after which the Solicitor General was heard. You were heard. For you to accuse the court like this is very unfair.
I'm being curtailed. My lords may pass appropriate orders, my lords. I can't help it because my lords who wants to, I leave it to my lords, my lords.
Yes, Mr. Chatterjee.
There are several cases lodged in this
When these cases were lodged, Mr. Chatterjee,
regarding the genuinity of
you
the
are representing whom?
I'm representing respondent number 15, who has lodged two of the complaints. Among these 4 complaints. Now, my lord, it has fallen from your nostrils. And why these complaints?
You are representing respondent number 15.
15, my lord.
Just
My lord, he has lodged 2 complaints. One is of Vishnupu and one is of Kalita Ashuti. Now, my lord, the question arises regarding the genuinity of these complaints, not the timing of this complaint. Because, my lord, timing things, my lord, practicability, my lord, kindly appreciates that it has fallen from your lordship that he has lost in election twice. But my lord kindly appreciates once he has lost more than 7 lakhs of votes. Subsequently, it was found that in their jurisdiction,
So since he has lost by 7 lakhs votes, that is the reason for.
No, my lord. 7 lakhs votes. Subsequently, it was seen that in that jurisdiction, the voter number is not 7 lakhs.
That could, Mr. Chatterjee, that could have been a ground of another FIR.
My lord, it shows that
Had it been a contemporaneous complaint.
it shows that how influential he is. He's super influential. My lord, before
So that's why, Mr. Chatterjee, court is not simply passing any order, quashing the proceedings. Now, I will permit the police authorities to proceed with the investigation. But why coercive step is necessary?
My question is, if he is outside of the custody, no common and sane man will come to come and depose against him. This is not possible.
Now situation is changed.
My lord, changed. That's why.
If your client would have filed a complaint, if your client would have filed a complaint contemporaneously and during the during that period,
Several
in
allegations
that event, your point which you are now agitating is germane.
My lord,
Yes.
before 4th of May, it was not possible for any common man to go and to lodge a complaint against this person. After 4th of May, my lord,
Then custodial interrogation was necessary, but now it is not necessary.
my lord. Otherwise,
Now situation is changed.
against him.
Now situation is changed, Mr. Chatterjee.
That's why.
Yes. So therefore, custodial interrogation is not necessary.
No person will come forward. He's mega influential.
Due to change of political dispensation, now there is a change of scenario.
I do not know whether he will come back or not. That I do not know. For that reason, my lord, kindly do not give any interim order. Kindly do not pass any interim order. My lord, in Amphan, crores of money was looted. Of money of common man that was looted. My lord, there are several.
Let him make his submission in the case, my lord.
My lord,
Not something which is not part of the case.
1 minute.
So very well, first point is influential person.
So, my lord, not only that. First,
Yes.
there is no ground. In paragraph 3, he has stated, I found the petition is extreme. Because several complaints are filed against him. No, that is not true. And
Oh, na, chole jao.
I do not know how can he say that illegal misuse of state machinery. They have used state machinery illegally for 15 years, and after 4th of May, when common man got the opportunity of coming before your lordship, they have started coming, my lord, regularly. Several complaints have been lodged. Number 1 ground will be there is no point, no ground in this complaint why interim order will be given to him, why interim protection will be given to him. There is no reason. My lord, a man, he has come before your lordship. I am asking myself, my lord, had it been a case of a common man, had it been a case of a common man,
Yes. If it is a delayed FIR, court is interfering.
my lord,
Yes. If it is delayed FIR, court is interfering. It can be perceived the intention of the person who lodged FIR.
my lord, my case.
But even this is too early. Investigation is at the nascent stage. Court is not interfere. Will not interfere with regard to the investigation which is to be carried out by the agency. But why coercive steps will be necessary if it is assured or ensured by the dint of this order the cooperation of the petitioner.
My lord, this man was attacked on several occasions. Whenever he has done,
But now the petitioner is being attacked.
attacked, my lord. After the
So that goes to show that there is a change of scenario.
no, my lord. My client, respondent number 15.
Yes.
He was attacked, my lord, on several occasions. He was admitted in the hospital. Several stitches were there on his head. That's
No, I understand the agony. I understand the feeling of respondent number 50. But would it be the consideration at the time of granting interim protection, permitting the authority to go on with the investigation?
my humble submission will be, these should be considered as considerations for not giving him protection, my lord. Because when this man was before 4th of May, he was super influential. My client was attacked on several occasions. He was admitted in the hospital because he was raising objections against this person. My lord, this is not a case that this man, he has never brought any allegation against this petitioner. No, before that, before this 4th.
Yes.
Before 4th May also, my lord, this man, he has lodged complaints. This is not the first time that after 4th May, when situations were
No, this court appreciates. So that's why investigation will continue and court will direct to cooperate. Yes, you are opposing.
I am opposing.
Yes.
Kindly do not give any protection because, my lord, he is super influential. And after 4th May also, my lord, he is influential. After 4th May also, he is influential. He is mega influential, my lord. Kindly do not give him any protection. He has already gone to America, my lord, with 25 bags. I do not know whether he will come back to cooperate investigating agency or not. Probably not. Probably he will.
That is beyond our knowledge.
Not be within my submission. But the fact is, he is still influential. Hence, my lord, kindly do not give any protection. Then my investigations will be hampered. No common man will come forward to depose against him or to give statements or evidences against him.
No, I understand the phases through which respondent number 15 and the plight of respondent number 15, which is being alleged. That perhaps the reasons for filing these complaints. So let these complaints be investigated upon.
Will be murdered, my lord. If this super influential person remains outside, my lord, he will be forced to withdraw the complaint. He will be forced
Now.
to, still now, my lord. He is
Still now.
influential, my lord. Still now, my lord. He is super influential.
Very well, Mr. Chair.
My lord, with the
Yes,
deepest-
Mr. Bhattacharya.
Yes.
Your senior has made
My
submission.
lord, my esteemed senior, my lord, was representing, my lord, some of the respondents, my lord. I am representing one respondent, if I am permitted, my lord. No, my lord, my lord, I had indicated, my lord, that I will draw, my lord, I'll distinguish, my lord, the orders of past year, my lord, Mr. Shubhendu Adhikari's case. No, my lord, my lord, only one thing, my lord, my lord.
Yes.
If your lordship gives interim protection to this petitioner, then kindly give protection, police protection to my client, my lord. Otherwise, he will be murdered.
My lord is having the list.
To my client, my lord. That's my.
My lord, only one thing,
Just a minute.
my lord, kindly, my lord, appreciates my.
Now, Mr. Chatterjee, 21st of May 2026, this court has already granted interim protection in one criminal prosecution.
I didn't appear.
No, that I know. That is because you are not the party there. And you had no occasion to appear in that matter. Court has already granted protection to the petitioner in connection with Bidhannagar Cybercrime Police
No,
Station.
Bidhannagar, it was up to 7 years. So 35(3), there is an
police station case. Now, please allow this court. Bidhannagar Police Station case number 75 of 2026. Now, after granting this protection on 21st of May 2026, whether any incident that respondent number 15 has been intimidated, because he is enjoying protection of this court. Any from May to August, any incident which your petitioner has confronted with.
My lord,
Please, Mr. Bhattacharya.
Kindly allow me.
Yes.
Yes, sir. Yes. He was threatened in front of media, my lord, that after 29 or 31, so all the হিসেব দেখা যাবে or something like that, my lord.
When this incident took place?
A few days back, in front of media, he was telling me, whoever lodged those cases or those persons will be taken care of subsequently after 29. 29 to 31. 31. FIR was lodged. FIR was lodged in that figure. One Rajiv Sharkar probably lodged a complaint against him also.
If he is so influential, then how his office at Amtala is being demolished, where court had to interfere, a coordinate bench?
No, my lord, I do not know anything regarding that matter because that office was not demolished or part.
Yes, it was being demolished, and so far I remember on Saturday or Sunday, and a coordinate bench having determination to take group fight order,
It was a Sunday, my lord.
interfered, and this demolition proceeding was stalled.
I will tell your lordship, my lord,
So it does not support your, Mr. Chatterjee, it does not support your contention that the petitioner is very influential.
No, my lord, neither that office was demolished at my instigation.
That I am not saying.
Persons or
Yes, that whether any influential person's office is being demolished within his constituency.
My lord, kindly appreciate, had he not been super influential, but he would not have dared to give any minor threat in front of media. In front of media.
Very well. So
His wife lost the complaint, my lord. Okay, this is
well, that is not part of this.
Yes, case number
Yes.
65 of 2026 that has been lodged against that person, that's the petitioner.
That was not the property of my lord, the petitioner before your lordship. It is the property of lips and bounds. And the difficulty arose because, my lord, the petition was moved on a Sunday when, my lord, we had no instruction. Now, my lord, immediately thereafter, no, I will tell your lordship, the property, it has been brought on record. The property which has been demolished does not even, my lord, belong to lips and bounds. That has been brought on record. The hearing is
No, before the before the era of present dispensation, political dispensation, this could have been done. I'm asking everybody.
Who do it?
So it goes to show that the situation is changed.
The question,
So
my lord,
at this stage,
let us not, my lord, avoid reality.
no, point of
Let us not avoid
the point
reality. My
is,
lord.
yes,
Put anybody.
yeah, right.
Put anybody, my
We
lord.
should not avoid the reality. We should not avoid, rightly submitted by learned advocate general.
Please, Panchayat,
Shall I give the number?
the-
my
No,
lord?
it's in the list, my lord.
That is not
the
part.
question. The Panchayat, the concerned Panchayat, my lord, allowed construction without any plan. The petition which
And perhaps, Mr. Mitro, that demolition proceedings started on Friday evening. Started on like yesterday's matter, rally matter. All proceedings are being started from Friday evening. And the court and the concerned and the court having relevant determinations is required to sit during weekend.
the proceeding, my lord, there sufficient notice was given that give
At
instruction.
least thrice I had to see.
That's a subject matter before another court.
The political leaders, they have started changing their colors. 21 MPs, they are sitting at Delhi, my lord.
And my lord had to also sit on a weekend and dismiss matters also, being frivolous.
Yes.
My lord had to sit and dismiss matters also on Wednesdays, being
Yes,
frivolous.
yes.
Yes.
CIT road one.
So, my lord, it's equally
Now,
valid
here, my
that
lord,
way.
I can tell your lordship, now it has come out. In fact, my lord, that was a point I argued before the court, my lord, the coordinate page. That, my lord, when they come up with an application, they have to, my lord, show that there is a plan. That was not there. Now, my lord, the recorded owner was given opportunity, my lord, to bring on record the plan. That was not availed of. Then, my lord, order was passed under
That
the act.
this matter is before another court, my lord. I'm sorry, my lord.
No, I have pointed out on
No, lordship
with
wanted
regard to the point taken by Mr. Chatterjee that petitioner is very influential.
Yes, super influential.
Well, that-
Now the merits of the matter is
That
pending.
possibly, my lord, my learned friend will not disagree that he is, my lord, a super influential.
But after change of political dispensation, how can it be?
My lord, still, my lord. State.
Every day,
How can it be?
one or two
Yes,
FIRs.
yes.
If your lordship protects my client, then my lord, not by state police, by CISF. This is my instruction.
But I'll just indicate one. I'll just take 5 minutes. One kindly permits me 5 minutes. The first is Shubhendu Adhikari, Sri Shubhendu Adhikari's judgment, which was cited, or the interim orders which were heavily relied upon. That is not applicable to the facts and circumstances of the case. May kindly take a note of the fact that in that particular writ petition, the prayers were alternative, quashing, or transferred to the CBI. The Honorable Court considered and transferred it.
How that is fatal if there is no prayer made for transfer to CBI?
I'm coming to that.
If I court proceeds on the premise that there is no prayer,
But
yes, there is no prayer in the
I'll come to
petition,
that.
that
It is there in
with
it is
regarding transferring
it is there in the final judgment of that particular case only.
even
there was
the
an-
court can
There was an
consider
objection.
whether interim protection is required. to
There
be
was an
granted or not.
objection. There was an objection as to misjoinder of cause of action, but taken in that case at the final hearing. The Honorable Court said that no, it should have been taken at the inception. Then they would have been directed to file separate petitions, separate applications. But since it is not being taken, or it is being taken at the final stage, and the court is hearing 2 writ petitions and 1 criminal revisional application, the court will not permit a technical pleas at such a belated stage. It is recorded, my lord, categorically, my lord, in para 2.2. Thereafter, my lord, internal page 119 of the judgment, and my lord, thereafter, my lord, at para 9.2.
That is the judgment of Justice Sengupta,
My
the
lord.
final judgment.
Yes,
Court is considering
my lord, in that
contemplating
particular.
to pass an interim protection.
Yes, my lord, I am taking an objection as
Time
to.
of passing interim protection to the petitioner in that matter, this was not an issue considered by the coordinate bench.
And my lord, in that particular case, my lord, I appeared in that case, my lord. My lord, all the orders, whatever orders were passed, my lord, after consideration of the case, Jaini.
No,
Yes, yes.
I appeared for the state. There was no question of on verbal submission, my lord, FIRs were state.
Very well.
My lord,
Anything
yes,
more?
yes. My lord, I say, Janto, এক মিনিট, আমি শেষ করিনি।
No, Mr. Chatterjee, please take your seat. Please take your seat. I will hear you later. Please take your seat. Yes.
Now, secondly, since my lord has indicated that my lord is keeping it confined to the 3 FIRs, but I say, my lord, I humbly beseech your lordship,
Yes.
my lord may kindly keep it confined to 1 FIR, because clubbing of investigation or clubbing of FIR, my lord, by way of filing an application under Article 226, my lord, that is impermissible, my lord, as that results to, my lord.
But in
Kindly
other
appreciate-
other matters which are relied upon,
But in Justice Sengupta's judgment, Pradeep Nirankarnath Sharma was not
there are
cited.
a slew of complaints.
I understand, my lord, but the law has been now laid down by the Honorable Supreme Court in Pradeep Nirankarnath Sharma's case, my lord. I kindly appreciates, my lord. This is not a very longish judgment, my lord. It's reported in 2025, volume 4, Supreme Court cases, page 818. I'll just give the paragraph
Just
to
a
you.
minute, just a minute.
My lord, my lord.
Come to the order passed in WPA 25552 of 2022. Dated 8
No.
December 2022.
My lord, I am referring to, my lord is referring.
Please come to that.
Orderটা বলছেন interim orderটা বলছেন my lord is referring to an interim order, my lord.
25522 of 2022, order dated 8 December 2022.
Yes. Yes, but that culminated, but that merged in the final judgment. But
Yes.
kindly takes para 33.
Please,
All
please,
interim
please,
orders.
please. There are 13 FIRs which are
Yes,
considered.
yes.
Not only this, no other coercive steps to be taken without leave of the court with regard to
But
other
what-
proceedings.
Yes, but that stood vacated. But that stood vacated. Kindly takes para 33.
And now you are taking this point,
But,
Mr. Bhattacharjee.
My lord, I am taking the point pursuant to, my lord, the law laid down.
Yes, that will be considered at the
Yes.
final hearing of this writ petition.
But
not
I am,
now.
my lord, I am on a question
Yes,
of
yes.
maintainability, and my lord, I am in fact.
And your senior has already made submission,
But
Mr.
I-
Raju. So therefore, no further submission.
My lord, only
Enough
one
is
thing, my
enough.
lord.
Yes,
My lord, may kindly, my lord.
Yes.
No, my lord, may kindly permit me, my lord,
hearing
to
is
cite, my lord, a judgment of an order of your lordship only.
Yes.
An order passed by your lordship, my lord. I am relying heavily on that. Etate, Somnath Shamtate. Yes, it's been, my lord, an order passed recently, my lord. It's a judgment, my lord. It's disposed of the writ petition. It's order was passed on 15/7/2026. তাড়াতাড়ি করতে হয়। Yes.
Before my order, I want to rely upon order of the Supreme Court, which you are relying
Yes, yes. Supreme Court, my lord, this is the order. My lord, may kindly take a note of the paragraphs, my lord. Eight to the hai. But Supreme Court, the decision, my lord, that I am citing is 2025 4 Supreme Court cases, page 818. The relevant paragraphs are, my lord, para 4, 5, 7 will be important. 8, yes, yes.
Just a minute. First Supreme Court order, judgment.
And this could not have been considered in 2022 because it's in 2025, my lord, that the Honorable Supreme Court delivered this judgment.
Yes, you are relying upon
Yes.
2024 4 SC, 2025 4 SC.
2025 4 Supreme Court cases, page 818, Pradeep Nirankarnath Sharma versus State of-
Paragraph.
the relevant paragraphs are, my lord, para 4, 5, 7, 8, 10 to 17, my lord. The ratio is, my lord, the first is, my lord, there cannot be a blanket protection. Second is, my lord, there cannot be several FIRs which can be heard together, which can be heard, clubbed and heard in a single matter together. So, my lord, this is the law, my lord, which has now been, my lord, and
Which paragraph it has been held?
my lord will find it in,
Take me to that particular paragraph.
my lord. My lord, kindly takes, there also, my lord, it was concerning, my lord, national resources, land allotment, etc. So, yes, kindly takes, my lord,
Just.
my lord.
Yes.
Yes, my lord, kindly takes para 11.
11.
Yes, I can skip over the facts, my lord, which are recorded above that, my lord. Kindly takes it up, my lord, from the third line, para 11. It was submitted that the appellant has sought a blanket order directing the authorities to conduct a preliminary inquiry before the registration of an FIR, which is impermissible under the settled principles of law. It was further contended that under section 154 CRPC, the registration of an FIR is mandatory if the information discloses the commission of a cognizable offence, and the police have no discretion to conduct a preliminary inquiry except in limited circumstances as laid down in Lalita Kumari. The state also asserted that there is no statutory provision requiring the accused to be given an opportunity to explain his position before the registration of an FIR, as such a practice would amount to granting an undue advantage to persons accused of serious offences and would hinder the investigation process. Additionally, it was argued that the appellant's plea, if granted, would set a dangerous precedent wherein public servants accused of corruption or misconduct could claim immunity by demanding a pre-FIR hearing. The respondent further contended that adequate legal safeguards are available to the appellant under the existing legal framework, including the right to seek anticipatory bail and the right to challenge malicious prosecution before the appropriate forums. Thereafter, my lord, para 13, the second line, the legal position regarding the registration of FIRs in cases of cognizable offences is well settled. This court in Lalita Kumari has categorically held that registration of an FIR is mandatory under section 154 CRPC if the information discloses the commission of a cognizable offence. Now, my lord, may kindly skip over and come, my lord, straightway to para 14. The scope of, my lord, may kindly skip para 14 also. It was pertaining to preliminary inquiry. Yes. Para 15, in the present case, the allegation against the appellant pertain to abuse of official position and corrupt practices while holding public office. Such allegations fall squarely within the category of cognizable offences, and there exists no legal requirement for a preliminary inquiry before the registration of an FIR in such cases. Para 16 will be important. The appellant's contention that successive FIRs have been registered against him with an ulterior motive is a matter that can be examined during the course of investigation and trial. The appellant has adequate remedies under the law, including the right to seek quashing of frivolous FIRs under section 482, the right to apply for bail, and the right to challenge any illegal actions of the investigating authorities before the appropriate forum. In para 17, further, this court cannot issue a blanket direction restraining the registration of FIRs against the appellant or mandating a preliminary inquiry in all future cases involving him. Such a direction would not only be contrary to the statutory framework of CRPC, but would also amount to judicial overreach. As rightly observed by the High Court, the courts cannot rewrite statutory provisions or introduce additional procedural safeguards that are not contemplated by law. So,
Furthermore, this court cannot issue a blanket direction restraining registration of FIR
yes,
against the
that is his
appellant
final relief.
and mandating a preliminary inquiry in
Yes.
all future
Yes,
cases.
that is what he has sought for in the.
Yes,
He
before
has
this
said.
court,
He has
Mr.
said that
Bhattacharjee,
no registration of FIR
no,
without leave. No, that is the prayer.
court is considering that whether petitioner is entitled to get interim protection, not to take coercive
But para
steps,
16 is the
not
answer.
to take coercive steps during continuation of investigation.
But that, my lord, is, my lord, again, my lord.
Your paragraph 7 makes the
16, my lord.
distinction.
No, para
It
16.
says further this court, I am very slow person in reading judgment, Mr. Bhattacharjee. Please, further this court cannot issue a blanket direction restraining registration of FIRs against the appellant or mandating a preliminary inquiry before registration. Whether this case is akin to the case which was considered in the judgment reported in 2025 for SCC.
But para 16 is the answer again, my lord. That
I need not go further.
but para 16, my lord, says that the regular recourse.
It is relating to registration of FIR and preliminary inquiry prior to registration.
16 is during the investigation. During
And here already registered FIRs are registered. Investigation is going on. Court is considering whether petitioner is required to be taken into custody or not, or any coercive steps are required to be taken. If order is passed, directions are given, ensuring cooperation of the petitioner with the investigating authority.
my lord,
How that judgment is applicable?
my lord, then comes my lord's order passed in my lord Somnath Sham's case.
Yes,
that
yes,
I have handed over.
No, I need not consider
my
my
lord,
own order
Para
after
7.
this judgment.
No, para 7, my lord. Para 7 of Somnath Sham, my lord has my lord relied on Niharika. And my lord has refused, my lord, the relief claim for and dismissed the writ petition. Airdrop.
Yes, concluded.
My lord, only one thing, my lord. I just repeat, my lord. My lord, may kindly pass an order upon consideration of the case diary, my lord, in these 3 cases, or my lord, in the alternative, my lord. And insofar as the Bidhan Nagar case is concerned, that my lord is relying upon, my lord, the order passed in May 2026, my lord. There, my lord, all sections were, my lord, up to 7 years, my lord, maximum punishment. But here, in respect of the Diamond Harbour Police District, my lord, 2 cases are beyond 7 years, my lord, the sections.
Yes.
So, my lord, may not pass that order, my lord, without, my lord,
not rely upon 35(3).
No, 35(3) was applicable in that case. So there is already an
So
inbuilt
here
protection.
35(3) is not applicable.
No, here 35(3) is not applicable. This is one, my lord. My lord, may kindly consider, my lord, Bhawanipur. My lord, kindly considers one FIR, not multiple FIRs together, my lord. And that is my humble submission.
That is a statement made on ex-handle. That is a statement made on
Yes, the
ex-handle.
Bhawanipur police station case, my lord. The Bhawanipur police, and my lord, one more thing, my lord, in both these cases, my lord, insofar as Diamond Harbour Police District is concerned, since, my lord, there was a delay, my lord, preliminary inquiry was duly conducted, and thereafter, my lord,
All Mr. Bhattacharjee in connection with election campaign.
election
campaign.
No, it was not with election. Diamond Harbour is not with election.
No, Bhawanipur.
Bhawanipur was with, my lord, it was a hate speech, my lord, which was given. But my lord, Diamond Harbour, both the cases where it's more than 10 years, more than 7 years, my lord, there was preliminary inquiry. My lord, there was a question from the Honorable Court as regards the delay. But there is no delay in so far as registration of FIR is concerned. There is a delay in so far as the reporting of the incident is concerned, my lord. But there, my lord, following Lalita Kumari, preliminary inquiry has been done. So, my lord, may kindly pass orders, my lord, if the Honorable Court is minded to pass any order, my lord. My lord, may kindly do that upon consideration of the case diary, my lord. Kindly directs me to produce the case diary.
The investigation is started, preliminary inquiry.
Yes.
court is not considering the prayer of the petitioner
No, it
that
is-
whether preliminary inquiry was required or not.
It is illegality, irrationality, and procedural impropriety. My lord, exercising powers, my lord, following the Wednesbury principle, my lord. I am on a more fundamental
Court
aspect.
is not, because you have crossed that hurdle. Preliminary inquiry is over, FIR registered, investigation going on.
But then Niharika will
Stage,
apply.
even if there is a prayer made in this writ petition with regard to preliminary inquiry, that is not even considered.
with
I am telling you.
With the deepest of humility, my lord, then Niharika will apply, my lord. But he can seek for a bail, for an anticipatory bail, in the event he apprehends, my lord, coercive action or arrest, my lord.
But what about Haji Iqbal?
No, Haji Iqbal is there,
What
but
about paragraph 102 of Bhajan Lal?
but no, 102 is different, my lord. 102, his case, my lord, even if we go by, my lord, the judgment of, my lord, Sri Shubhendu Adhikari, Sri Shubhendu Adhikari's case was, my lord, malicious prosecution. Here, my lord, they have only alleged, my lord.
There are judgments in appropriate cases by the Honorable Supreme Court. Now, this court has to consider that what are the, considering the facts of the case, which one is applicable.
But for ascertaining the facts of the case,
judgment,
for ascertaining the facts of the case, my lord,
but at the time of Mr. Bhattaji, I am telling you, at the time of, though this court has initially expressed hesitation at the time of hearing of this matter, that whether the FIRs where particulars are not disclosed, or whether the multiple affairs can be gone into in one writ petition seeking quashment of a proceeding. But I have come across several orders passed by coordinated bench in other matters where more than 10, 15
Yes,
FIRs were
but-
taken into consideration. Not only this,
But-
no other proceedings without leave of the court.
But Pradeep Nilankarnath, my lord, was not considered. Pradeep Nilankarnath, my lord, I have taken your lordship to para 16, my lord. And my lord, the honorable writ court, my lord, it's a discretionary jurisdiction.
Yes, yes,
482
Mr. Chatterjee, what you are trying to, I understand.
One thing, my lord. Number one, my lord. Sri Shubhendu,
Yes.
I am not touching his submission. This is my own submission.
Because Mr. Chatterjee was trying to,
My lord, only one last, my lord, submission, my lord, that I'll make, my lord, for my satisfaction, my lord. But the honorable Supreme Court, my lord, Haji Iqbal, my lord, has one aspect. But the honorable Supreme Court, my lord, says in 2012, 10 Supreme Court cases, page 155.
in Haji Iqbal, paragraph 14, it is observed that attending circumstances need to be taken into consideration.
Yes, but again, 2012-10 says the honorable court cannot go into, or the police has no discretion to see who is the de facto complainant. The police has no discretion to verify the antecedents. The duty of the police is, my lord, to have a look at the FIR. If it discloses a cognizable offense, there is no other discretion but to
But
register.
FIR has to be registered.
And, my lord, the honorable court, my lord, in exercise of powers under 226 or 482, my lord, it cannot go into, my lord, a mini trial before, my lord, evidence is collected and, my lord, the investigation.
all.
Oh, I understand. My lord has indicated that. My lord has indicated that.
No observations with regard to the
My lord has
contents of the
indicated
FIR.
that. My lord has indicated that.
Because
I'll just.
that will influence the investigation
My
and
lord,
the
I am, my lord, I am on a more practical, my lord, angle, my lord. Now, my lord is saying, my lord, that he will cooperate. I'll put him to terms, but don't take coercive actions. He will go there. He will sit. He will say that very well. I am cooperating. This is my cooperation. I am here. I have presented myself. After, my lord, a week, he will come back. My lord has taken judicial notice, my lord, of, my lord, the
court passed order in similar
no,
situation.
past orders, and my lord has seen, my lord, the present indifference, my lord, insofar as, my lord, even, my lord, the proceedings before the honorable court are concerned, my lord. He also, the honorable court volunteered to send him to, my lord, a medical board. It was a very simple thing. He was, my lord, he did not even have, my lord, the, my lord, minimum decency also.
I would not make any comment because there is
No, it's my submission. My lord may not make any comment. My lord may kindly appreciate. Even despite orders passed by your lordship, my lord, the state had to come up by way of an application to direct him to cooperate for collecting voice sample. So what he will do? Yes. So, my lord, I am on a more practical aspect. After a week, he will come back and say that see, I am cooperating. The police has called me. I have been there. Now they are harassing me. So, my lord, the investigation.
It does not anticipate the problems which may arise.
No, my lord, this is
Then
the.
will come up. Then you approach the court seeking.
But this will happen.
Let us not anticipate.
No, this will happen, my lord. This will happen, my lord.
Yes,
Otherwise, my lord, but this will never stop, my lord. The
In that
226
application, subject to what my learned friend
when
is
you
saying.
want to stop it,
my lord.
When you want topics.
But it has to be a meaningful cooperation. He cannot go and
Up to
sit
this
alone.
only.
He cannot go and
Up to
sit.
this only, not beyond.
No, but at this stage, my lord, without looking into the case diary, my lord may not pass, my lord, the orders, my lord.
Yes. Yes.
Lines, my lord, without touching Mr. Bhattacharya's submission.
Ever in-
Mr. Shubhendu Adhikari's case is not at all applicable in this case because Mr. Shubhendu Adhikari, while he was opposition leader, he was attacked 30 times. 30 times. And my client, he was attacked 4 times.
No, no.
my lord,
That case will not set an example so far present case is concerned because the circumstances are different. You are absolutely correct. But the order passed in those matters are being relied upon whether in one writ petition multiple FIRs can be considered.
Absolutely.
Not beyond that.
My submission is.
You are absolutely correct. The facts are completely different.
And my lord, I have also lodged other complaints wherein there are complaints regarding Shebas Roy. In Shebas Roy complaint, my lord, your lordship.
No, this is not the subject matter of this writ, my lord.
She has lost her leg.
Let him make submissions to confine to this writ only.
PCPNDT acts are also there, my lord. So, my lord, if your lordship passes or not, I do not know what will fall from your lordship. But my lord, kindly.
That is pending. Lordships can take that
Whenever
matter.
necessary, if police calls him, he has to attend the police station. And my lord, this should be the prayer from state government side. If he does not cooperate, then liberty should be given to us, at least to my lord, modify the order, my lord.
Us
Liberty should be given.
to the de facto, my lord.
Cooperate, my
He is
lord.
the de facto.
Come before your lord.
Only one.
But I have,
My lord,
if I can just take 2 minutes, just 2 minutes.
and my lord, only one thing, my lord, may kindly go through the pleadings, my lord. These are all on surmises and conjectures.
Yes, Mr. Shankar.
Yes.
But I'll just hand my lord list, my lord, indicating, my lord, the ratios on which I am relying upon, my lord. The compilation, my lord.
I will just take 2 minutes, my lord.
Yes.
Very briefly.
Yes.
Para 102 of Bhajanlal, your lordships have read with reference to both Article 226 and 482. That is what I'm relying on. Second, the cooperation aspect that they have made much of. Please note page 14 of my writ petition, where I have mentioned the instances of cooperation by me, where I have gone and I have been interrogated for extensive periods of time. That's at page
Again, a
14.
misstatement, my lord. I indicated that on the first occasion.
Just a minute, allow him. Allow him. He did not obstruct you. Mr. Bhattacharya, please take your seat.
There's no seat for that.
Please take your seat. That is not the way to address the court when elaborate submissions are being made. And you are an additional advocate general.
Page 14 bottom has a table, my lords.
Yes, cooperation by petitioner, you are relying upon page
14, bottom of page 14. That was up till the
of writ petition.
of writ petition.
Just
Page
a minute.
14, 1-4.
Hey, writ petitioner copy to the. Yes, page 14.
Yes, I just want to draw your lordship's attention. I'm not reading it out. Just that table. Your lordship will
Yes.
see the table at the bottom. That
Yes.
shows the cooperation that is taking place. We undertake, of course, to cooperate with any of the investigation. I'm not pitching it that high that I'm saying stay of investigation, etc. at this stage. I'm saying that we will join. There's no issue with that at all. So I don't think that apprehension needs to be there. The third point, my lords, is that my friend, the Lord Additional Advocate General, has repeatedly said that that 8th December 22 order in Mr. Shubhendu Adhikari's case was an interim order and that has been vacated. I don't think that expression is correct. It's not been vacated. In fact, of the FIRs that had been registered against Mr. Adhikari, 2 had been withdrawn, 13 came to be quashed. So that works in my favor, in fact. The interim order goes halfway.
What is your contention? 8 December 2022 order passed in the case of
Mr. Suvendu
Yes.
Adhikari was an interim order, is the argument taken against me, saying that it got vacated. It did not get vacated. In fact, the final judgment held completely in Mr. Suvendu Adhikari's favor, and it quashed 13 FIRs. 13 were quashed by that final judgment. Para 9.3, your lordships will recall, I read to your lordships last time, on the reasoning as to multiple FIRs in a single writ.
Yes.
So
that is the judgment of Justice Sengupta.
Yes, my lords, absolutely. Of 24th October 25. I'm saying this
Consecutive paragraphs were relied upon,
Correct.
one by on behalf of the state and another on behalf of
one by me.
by the petition.
9.2 and 9.3. Those are the two paragraphs. I'm just saying that it's improper to say that the interim orders were vacated. Interim orders were in fact absolute, confirmed, and the underlying FIRs were quashed. 13 FIRs were quashed. 2 were in fact withdrawn by the state, and 1 the court did not interfere because Mr. Adhikari was not an accused in it. So they said, at your instance, we're not interfering because you're not an accused in it. I just want to give you the true picture. 16 FIRs, 13 quashed, 2 state withdrew, and 1 there was Mr. Adhikari was not an accused. Right, Manoj? Third, on these 2 judgments that they've cited before your lordships, I don't think either of them apply, but the Somnath Sham order of your lordships, I think, was referring clearly in paragraph 4 to the question of whether there has been a violation of any fundamental rights, etc. I think that question doesn't arise
With the
here.
copy of this order, my order,
Yes.
Somnath Sham,
I've handed over.
that you have handed over.
Yes.
Yes.
The compilation, part of the
But the compilation, it's a part of the compilation.
Filed on behalf of the petitioner.
No, it's filed just now, my lord.
Is order dated?
It's the order dated.
Yes, Somnath Sham.
Yes,
order
yes,
dated
Manoj.
15 July.
15 July.
Right.
Just see the argument of my friend Mr. Bhattacharya, my lords, which your lordships accepted at para 5. The argument was that unless a case is made out alleging violation of fundamental rights, writ court, while exercising jurisdiction, may not entertain writ petition. This was not a case where there was a 5-year delay. This was not a case where a political opponent had filed the case. This was not a case where 16 FIRs had been registered. And this was not a case where the FIR was registered immediately after the election results were declared. There are 4 factual points of distinction, which brings me to my arguments on Article 14 and 21. Therefore, this order, my lords, which was in a singular FIR, not a pattern, not dealing with electoral enmity, cannot at all be pressed into service against us. This, and the other point is, in that Somnath Shah's case, my lords, there were criminal antecedents. My instructions were, there were 10 criminal antecedents at least that Mr. Ichini Somnath Sham had, which is not the case in our case at all. There's 0 criminal antecedents. Nil. Mr. Bhattacharya, let me finish.
I didn't say anything.
You said, my lords.
Yes, Mr.
And then finally, on the Supreme Court's order, which was relied upon, my lords, by just now, that was an order of the Supreme Court dealing with where a preliminary inquiry was sought mandatorily from a 226 court, and 2, I'm sorry, what's the name of this?
Yes.
What's the name of the judge?
That is 2025 4 SC 818.
Correct. Pradeep Nirankar Nath Sharma. But in that, the prayers made by the petitioner after the High Court had dismissed his plea, the prayer was that in every case you will have a preliminary inquiry when it concerns me.
That is what I have told Mr. Bhattacharya in
Lord.
reference to the observation made in paragraph 17.
Absolutely.
With regard to preliminary inquiry and registration of FIR.
Correct.
And it is over so far the present case is concerned in all 16 FIRs.
Yes, Manoj. Absolutely.
Court is considering 3 FIRs.
I am most grateful. Now, one last point, Manoj. That chart which was handed up to your lordships of those 16 FIRs, if your lordships could take that.
Yes.
One page.
Just for the purposes of clarity, my lords, I suspect we will be troubling you with that chart even
Just
on future occasions.
Supplied by them.
আমি তো সিঙ্গেল পেজ দিয়েছি একটা
হ্যাঁ,
Yes,
ওটাই।
single page. The single page with 16 FIRs listed on it.
Just a minute.
Yes.
Probably that one, Malad. Yes, this one. This one.
Yes.
Yes, yes, yes.
I just, for your assistance, if your lordship could just mark in the margin, serial numbers 2, 3, and 12 are the subject matter of this writ. 2,
Right.
3, and 12. My lords, separately,
And 12.
see 2, 3, and 12. Separately, serial numbers 6, 7, and 11. 6, 7, and 11
Yes.
are subject matter of the other writ listed today, my lords. Writ petition 19982, which is at serial number 93 of your lordship's board. That is 6, 7, and 11. The interim orders which the court has passed in the past, protecting me, my lords, has come in serial numbers 13 and 14. Serial number 13, because your lordship was asking this query, I just wanted to help. Serial number 13 is the one in that revision proceedings that's dated 11th June 26. If in the margin your lordships could jot down, 11th June 26 is for serial number 13. And serial number 14 is 21st May 26.
So in this writ petition, you are questioning serial number 2, 3, and 12.
Absolutely.
Yes.
The other writ on your lordship's board is dealing with 6, 7, and 11. The interim orders which your lordships have passed is in 13 and 14.
Up to 17.
For this, Malad. For this up to 70.
Yes, yes, yes. So in this matter, your lordships have extended up to 17th. My plea, my lords, today is to make that absolute until the matter is disposed of.
No,
That-
what I have thought that this
Yes.
matter will come because it will take some time to dictate order. So this matter will come under the heading for order for passing an order, and up to that extent, and that's why there will be further extension of interim order which was passed on earlier, which is subsisting.
Maybe we have
till-
filed a can for this.
Yes,
till further orders then, my lords.
yes.
Can,
Yeah.
only
can one,
two
Malad.
things, my lord, regarding the I distinguish the judgment, my lord, in case of Sri Shubhendu Adhikari, but I've just made a chart, my lord, indicating the relevant paragraphs. And my lord,
My lords, I have one last plea. My lords,
my lord, only one thing, my lord, one judgment, my lord, that remained not cited by me, my lord. It's reported in 2009, 5 Supreme Court cases.
Interim order passed earlier stands extended till 31st August 2026 or until further order, whichever is earlier. Stop. List the matter under the heading. List the matter under the heading for order on.
loaded. Yes.
25th August.
My lord, may I do this, my lord?
Can
Then?
I have a small plea, my lords.
Can one
small-
for extension.
Malad.
Let it be disposed of. Yes. Give the
No,
number.
Yes, sought for extension till
Application
Can one.
26. Filed by the petitioner seeking extension of interim order is disposed of.
no
My lords, I
extension
have one more request. my
till
lords.
disposal of the writ petition. That is the prayer in the can.
That is in view of this order that is disposed of.
My lord, may I, my lord, only one. But may I submit a small note by Thursday? May I submit a small note by Thursday? That will actually aid in passing of the interim order.
If you can, court is not directing. If you want, you can.
I will, my lord.
Yes.
My lords, I have one small request.
Sauce
One
for the
small
gander
request.
is sauce for the goose. They did not hand me over a copy, my lord. If they hand me over a copy, I'll give them a copy.
No, we'll hand over. There's no
Don't, my
question.
lord, I won't.
We'll hand over. We'll hand over, Mr. Bhattacharya. It's my responsibility. I'll make sure it's handed over. My lords, may I make a request? I can't hear what.
Yes, Mr. Shankar.
One small request. The
Yes.
16 FIRs that my friend has handed over, We have
Yes.
checked on the website, my lords. The first page of the FIR is there on the website, but the underlying full FIR with the complaint is not available. I was just wondering because we have made efforts going to the police stations and trying to obtain it. That has not been forthcoming. If some way your lordships could just encourage them, if they could just share those copies with us, that I don't want to trouble the court with them filing, etc. Just give us permission. Our lawyer will go to the police stations and we'll make requests and it can be given to us.
I don't know. It's come sudden. It's coming sudden.
Upload it, my lord.
It's coming suddenly, my lord. I cannot, my lord. I can. They have to apply, my lord, with the GN number.
It's not
With the GN
uploaded,
number.
sir.
They have to. They have the numbers.
Should
They
have
have
been
the
uploaded.
numbers, my lord. They have to apply for with the GN number for a certified copy. That is the system. I am not teaching anything, my lord. Since new proposition of law is coming, my lord.
There, it is not there in the portal.
My lord,
Before the next date, concerned police authority is directed to supply copy of all the FIRs in connection with existing criminal prosecutions
With
to the
complaints,
petitioner.
my lord. With
I'm
complaints.
most grateful.
but
With the complaints, my lord.
But that is
Complaints, those are not
but that
uploaded.
is not a prayer here, my lord. They have filed a separate writ petition.
It is a prayer.
They have
It's prayer
they have
G.
filed a separate.
It is prayer G. It is prayer
They have
G of
filed
our
a separate writ petition also now, my lord.
It's prayer G of our petition.
But they have to apply for certified copy, my
Mr.
lord.
Bhattacharya, you are appearing for whom?
I am for the state, my lord.
Mr. Raju has appeared.
Yeah.
That
Sir
is
has also
creating
appeared.
difficulty.
No. I will
Sign the order.
I will indicate, my lord. 3 to
Because-
13,
No,
my
no,
lord.
no, please clarify it. Please clarify it. Because your name and Advocate General, Learned Advocate General's name uh, uh, were transcribed twice.
Yes. For respondent number 1 and 2.
3 and 13.
For respondent number 1 and 2, the Learned Advocate General is leading me, my lord. And for respondent numbers 3 to 13, my lord,
Mr. Raju.
Mr. Raju is leading the team, my lord.
But you are both of you, Learned
Yes.
Advocate General and Additional Advocate General, are appearing in both on behalf of respondent number 1 and 2 as well as 3 to 13. Yes, there is no dispute with regard to your appearance.
So, my lord,
We are also not raised.
my lord, let them indicate the FIRs they need, my lord.
16 FIRs.
16.
You have given the chart
Yes.
in terms of previous order. So supply them copies of the FIR and complaints before the next day.
Very grateful, Manoj. I'm most grateful.
Very great. Very
Manoj, I'm sorry that we took so much of your lordship's time, but very
But I
grateful.
have handed up that chart, my lord, distinguishing the chart is there, and my lord, another judgment, my lord, that I indicate that in the note. Note indicate করে দেবো সুবিধা হবে যশ কিসের রে না ওটা দেবো
Yes, you are all of you are released because I will rise for 10 minutes. Let me arrange papers in according to my own way.
Grateful, Manoj.
Yes. এটা এখানে রাখো তলায়।
Under the next matter, the report was to be filed.
Just এর একটা ইয়ে কোথায়?
না এটা নেই গো পাড়ার ব্যাপার তো তাই নেই
ও হ্যাঁ
পছন্দ করি না কিন্তু হ্যাঁ
এখানে আমার নোটস কোর্স গুলো আমি নিলাম না। দেখো ওই ফোল্ডারটা দাও তো, লুজ ফোল্ডার। হ্যাঁ দাও তো, লুজ ফোল্ডার হলে দাও, এটাই হবে। এটা তো এইটা সাদাটা আছে দাও। দাও ব্যবস্থাই খুঁজছিলাম।
আগের দিন আমি জমা দিই। এই তো সার্ভ করেছি। না করতে হবে।
Till 17.
Yes, yes, Mr.
The next one, my lord, the report was to be filed.
Lord, I am
Yes.
for the petition.
Lord,
Lord, I am also for extension of interim order, my lord. We have filed a can, my lord, upon service to all my my lord friends.
Item number 3.
Because Advocate General is there for,
Lordships, lordships.
is here in the, from morning.
Yes, yes,
But
absolutely.
this will not take time, my lord. That is why.
My lord had
That
called,
matter, that
my
matter.
lord had called for a report, my lord.
Two reports.
Two reports, which is reflected from the last order also. Thrice we have complied.
So interim order is till 17th
Till
of
17th, we have filed the can, my lord, for extension of interim order, my lord. And
Yes, file your reports, Mr. Mitro. And appeal was preferred, intercourt appeal
yes,
was
by the
preferred.
de facto complainant.
Yes, what is the fate of that?
That is coming up
That
on
is pending.
27th of August, 27th or 28th.
You are representing. De
No,
facto.
no, no, my lord. We are
I
the
am
respondent.
defending the de facto.
Mr. Jana is for the de facto. He is the appellant before the my lord division bench. And that appeal, my lord,
Let me extend the interim order for some time and
Lordships.
taking the reports on record.
Lordships. The appeal is coming up on 28th.
In the meantime,
since I
the
am-
order is, if any order is passed by the appellate
We'll-
court,
we'll
then that will be
communicate.
considered by this.
My lord, since I am the de facto complainant as well as the victim, my lord, may I get a copy of the report?
But then the
My
report can be,
intent, no, my lord, my
can be
entitlement
circulated
to
to
get a
all
report
of us, my lord.
is always.
No,
No,
in one
he's-
matter where I directed Bidhan Nagar's commissionerate, commissioner of Bidhan, I directed that will be only for the consideration of this court.
No, my lord, kindly sees the,
He's an
see the
accused also
order.
in another case.
My lord, kindly sees the report. Kindly sees
One
the
is
order.
by the Director General and Inspector General of Police West Bengal, being respondent is directed to submit a report disclosing progress made in the investigation.
No, my lord,
That
kindly comes to
will
the
take.
first order. The first order dated 10th June. My lord, kindly comes
But
to
the
paragraph
Commissioner of
32.
Police, Bidhan Nagar Police Commissionerate, that is for the, for consideration of this court, you will not get this.
My lord,
He's also an accused in another case relating to the same event. So, my lord, he also.
I am accused in connection
Yes,
with
yes,
that
where are
case.
the
My
reports?
case,
But
Mr.
my lord,
shielding
the
himself.
direction
Mr.
was
Mitro,
there
where are the reports?
to make an independent inquiry as to
Mr.
why event
Mitro,
could
where
not
are
be
the
organized appropriately. That was the
Where are the reports?
My lord, I have the report of the Commissioner of Police, my lord. The DG report was.
This will be
32 and 28. We don't know.
If it is not ready, then take time.
No. So far paragraph 20 it is concerned, my lord, I am not entitled. But so far paragraph 32 is concerned, my lord, kindly, my lord,
Not
consider
at
my
this
prayer.
stage. Not
No,
at this
so far
stage.
paragraph
That is
32.
that is not a case made out in this writ petition. It is for the court. Court has made certain observations with regard to that event to satisfy consents of
My
this.
lord, subject to
directive.
correction,
Yes.
subject to correction, my lord, this has a direct bearing with the allegations that has been made by the victim.
Maybe
For paragraph 32 is concerned.
let the
Yes, whether
investigation
reports are ready,
conclude.
no. File it.
The de facto cannot be a backseat driver, my lord, with greatest respect.
ওটার একটা কপি স্যারকে দিয়ে রাখো।
Please.
Issue.
My lord, may I submit only, my lord, may I make a very small submission?
Mr. Surajit Nath Mitra, Learned Advocate General, representing state respondents, has filed, has filed two reports. One is dated 3rd August 2025, 2026 of Director General and Inspector General of Police West Bengal, and another is dated 10th August 2026 of Commissioner of Police, Bidhannagar Police Commission, comma, those are taken on record. Next paragraph. Let copy of the report dated 3rd August 2026 of Director General and Inspector General of Police West Bengal be made over to the learned.
Your lordship wanted to know, my lord, kindly for the time being, kindly.
No, regarding Bidhannagar Police Commissioner's report, I am not directing you to circulate. Only the report of DGIG. Because that was regarding the observation made by this court with regard to that incident happened in December 2025.
There is no other
Made over to the learned advocates representing the petitioner and respondent number 5. Next paragraph, interim order passed earlier stands extended till
My lord, kindly come to the report once. The last page.
which report?
The DIG.
Second page, meaning by the second page of DIG report.
No, the annexure.
Annex.
Whether there is any other pending case
Yes.
against him or not, and secondly, what is the progress of investigation? There is no other pending case against him, but progress of investigation, they are not supposed to get it right now.
Well,
No,
the
the
report,
fact
report
is
which you are
that
not
I am-
called for in terms of para 28. My lord, only I'm asking myself, my lord, what business would the respondent number 5 have?
My lord,
in
I
having that
have.
report, my lord.
My lord, may I
28, I am not directing to circulate this report.
Lord,
Only DGIG's report I am directing.
yes, in paragraph 28 only, my lord.
that is para 28.
28.
That is para 28.
DGIG
my lord.
report.
Yes.
Page.
Statements are the statement only.
My lord, the last page, my lord. for
Page
something-
7 of Deputy Commissioner of Police, Bidhannagar Zone, dated 3rd August 2026.
Lordships.
Yes.
My lord, second paragraph at the top, be it mentioned.
No, my lord is looking in the to the order.
Has been fixed on so and so date. Each statement in one, they are not supposed to get it done. It's the stage of investigation. 164 statement have also been.
এখন জোড়া জানবে না।
And my lord, the penalty.
Just a minute, and not to take any person steps. Institutions. Okay. Institution. It is on June, 18 June. I don't think that is correct.
13th.
Because this order was passed in the month of August, 4th of August.
As per the order, my lord.
10th of
No,
June, my
10th
lord,
of
had
June,
passed
the
the order.
first order.
10th of June.
The first two.
Yes.
And then the next
And
paragraph.
that's a statement. Statement was recorded in such a submitted. Statement.
Concerns the investigation.
Yes.
The paragraph starting with recording of
Yes.
the name is mentioned. My lord. The name is mentioned, my lord, who would be interrogated, the particulars are given. So, my lord,
So that's why you are praying not to circulate.
not to
My lord, the report.
Made over.
No, my lord, may I just submit one thing, my lord, subject to correction
He's an
and
accused.
exception.
In the same case,
My lord, I am not an accused.
he's on bail in the first case.
Extended. Interim order passed on
10th of June.
2026.
My lord, so far, my lord,
Extended till 30th November 2026 or until further order.
only one submission of mine can be recorded that pursuant, there was a condition of your lordship's order that I must comply with all notices. I am giving your lordship 3 dates, my lord. 18th of June, 22nd of June, and my lord 7th of July. I have annexed those also, my lord, in my can. Pages, my lord, 15 and 16.
You appeared.
I have appeared.
Yes,
and
yes. That is reflected from the report itself.
Very good, very good. My lord, that I do not know, my lord.
My lord, I have a very small
Short-
submission,
short-
very short submission.
Not
Vacation intervened in the meantime. Prior to vacation, several matters are fixed. Come back on 30th November.
And I have been complying.
On 30th November 2026 or until further order, list the matter or until further order, whichever is earlier. Stop. Next paragraph. List the matter under the same heading for further consideration on 17th November 2026.
And my lord, it will not.
Application being Can 1.
Can 1.
Application being Can 1 of 2026 seeking extension of interim order filed by the petitioner is disposed of.
My lord, I have a very small submissions, my lord. My lord, so far paragraph 32 of the order is concerned, my lord, I am entitled
No,
to get
today I will not direct to.
My lord, so far paragraph
because
32
investigation is
my
going
lord,
on.
sorry, my lord, because it has a direct bearing with my allegations.
He wants to
Not,
create
my
a
lord,
defense.
It will not preclude pilot filing of pilot charge sheet before the learned court pilot.
My lord, your lordship cannot say charge sheet, my lord.
Right.
Yes.
Yeah, otherwise
Lordship
the
can-
theme
your
of the
lordship
act,
can
my
say
lord,
report in
entitled to
final
me.
form. Perhaps, my lord, subject to correction.
However, it is made clear that pendency of this proceeding shall not preclude the investigating agency to take steps with regard to ongoing investigation and to file report before the jurisdictional magistrate.
Great, obliged. ঠিক আছে
ভালো তৃণমূল
obliged.
On the last occasion.
Number.
Call who?
Please call the list.
Item number 4. My lord, on the last occasion, my lord was pleased to call for a report. Asked them to seize the documents which I had alleged to be forged. The FIR has been pending since 4 years almost.
Yes. Report. Whether authorization letter and agreements are seized.
There is some catch in this, Lordship.
Which page? Which paragraph?
Lordship may kindly, there's a page which I have dog-eared. If my Lord may kindly take up that page. B9, that is annexure B9.
B9 and B10.
B8, my Lord may kindly take up B8, the page previous to B9. A notice was sent to the district controller, Food and Supplies Malda, for original copies of the agreement.
Third page.
No, Lordship, annexure B8.
Oh.
Annexure B8. I have dog-eared the page, Lordship. The page prior to that, if my Lord can kindly look at.
B9.
B8 first and then thereafter B9.
Yes. Just a minute.
একটা করে দেখাই।
Yes, this is the letter for by which
This is one of the first letters. Lordship may kindly turn over the page.
Yes, B9.
The person who had in his custody these two documents.
This is the response of to your letter.
This is not per se the response. The response is later on. I want to show this page to bring on one fact.
How missing of Hirak Ghosh is relevant?
It is relevant because these documents were with him. Lordship, I am not trying to shy away or anything. My lord may also take.
What is he is working in
Yes.
food and supplies department?
Yes, he's the food inspector with whom apparently these documents were in whose possession these documents were in. Lordship, I've spoken to senior officials with respect to this matter. I will require some more time. There is something that more does not meet the eye.
But how
If I may
police please, how police comes to a conclusion that these documents are lying with Hirak Ghosh?
Because he was he was the official who was in charge of that department and who he was at the material point of time, and it was handed over. My lord may kindly take page 11, B11, annexure B11. It is mentioned how Hirak Ghosh had come into being. It was produced by him and it was again given on Jimannama bond back to him.
But different case number is stated 315 of 2023. But it is in case number Harishchandrapur case number 1141 of 2020.
That is the case against the petitioner. This document is relevant for both cases.
There are two cases.
Two cases, case and counter
case.
case and counter case.
But in counter
case and counter case,
315 of 2023, charge
Sheet has been filed.
So then how it is relevant?
It is relevant in the case which is pending basis the complaint of the writ petitioner. Kunta.
It was under Jimma of
Hirak Ghosh.
He is the complainant in that case against me. 2022, I filed the case, my lord, saying that my signatures were forged. I had resigned way back in 2016. 2022, this director forges my signature and procures a food supplies order and then defaults. Then defaults. And then the food supply goes on to file a case against me as well as the other directors. And my case is not being investigated. Hirak Datta had custody of all the documents, my lord. He files the case against me and he submits the charge sheet. And my case remains lying for 4 years.
It is wrong to say that it is not being investigated upon. It is being investigated upon. I am not joining issues with my learned friend here. I can understand what is going on, at least from a bare perusal. B13, lordship, if my lord kindly takes a B13, that is also very material. So now I have roped in the food and supplies department also. I've spoken to the higher officials in that department also. My lord kindly, if my lord may give me at least 14 days time, I can find out, because these are all legacy matters, as my lord may know. So
yes,
these are all legacy matters, baggage of legacy. B13.
B13.
And I am facing criminal.
Now they say that this document is not there in the office. একদমই ঠিক কথা।
Now, if police knows that the documents, this agreement and authorization letter are lying with Hirak Ghosh, then why those documents were not recovered during such a long time from 2022 till 2026?
And the irony is, my lord, I am
My lord
filing a
now
criminal
understands.
prosecution based on.
I believe my lord now understands the
Just
necessity
state.
for custodial interrogation at in some cases.
I'm not recording anything.
No, my lord, kindly gives me
Issue.
14 days. I will
Issue. In terms
look
of
into
order
this.
dated 8 July
May I get a copy?
2026, a report
SP number. Principal Secretary Shadab.
dated 10th August 2026 of officer of sub-inspector Bhaluka outpost under Horishchandrapur police station, along with certain documents are filed and same are taken on record. Next paragraph. However, Mr. Das, learned additional government Peter, representing state respondents, prays for time to take steps in Horishchandrapur police station case number 1141 of 2022 dated 28 December 2022. In terms of order dated 8 July 2026. Stop. Petitioner is represented by learned advocate. Next paragraph. Acceding to the request made on behalf of the petitioner, hearing of this matter stands adjourned. Stop. List the matter under the same under the heading new motion 1 on September 2026. Huh? State respondents. Right.
And may I request one thing, my lord? In that 315 case, my lord, can my lord directs them not to take any coercive action against me, my lord?
No, sir. That's too big. That is beyond the jurisdiction of
The warrant is pending in that.
Oh, sorry. Next matter. You take steps for that.
Item number 5. TRR আছে তো একটা file করা।
Five, my lord, I appear for the petitioner, my lord. My lord, the live streaming may be paused because this relates to sexual offences, my lord.
Live stream বন্ধ করে
6.
My lord, I appear on behalf of the petitioner, but there's no respondent here, my lord. There's no private respondent in this application. But this matter concerning, my lord, police inaction, the accused would not have any say in the way the investigation proceeds.
That's the
My lord.
yes. What you are paying for?
Lord, I'm praying for, my lord, transfer of investigation to the detective department. But my lord, your lordship will kindly not grant me that, my lord.
Already FIR has been registered.
FIR has been registered. but not
Registered on
post-
10th March
Yes, my
2023.
lord. What I am aggrieved with is the inaction in investigation, not non-registration, my lord.
Matter is heard in presence of the learned advocates representing the petitioner and state respondents. Next paragraph, a case is made out in this writ petition whereby mandamus is sought for, thereby directing the police authorities to take steps in Tiljala Police Station case number 124 of 2026 dated 10th March 2026.
My lord, may I be permitted to submit?
Stop. It's not required. Please hear the order. Stop.
May I pray for just one indulgence, my lord?
Stop. Prayer is also made for directing the police authorities to file report before the jurisdictional magistrate on completing investigation. Next paragraph, state respondents are represented. You are for the both of you are for the state.
I'm for the state, my lord.
You are for
Private respondent number 629.
There's no private respondent.
Private respondent number 629.
6 to 9.
There's
My
no
lord,
private
I
respondent.
have to pass
Private
this
respondent numbers.
629.
But I've not
There are
added.
respondents up
Yes,
to
my lord,
5.
I need to disclose. My
There
lord,
are respondents up to 5. There is no 6.
Yeah.
my lord, kindly come to
There are respondents up to 5. Answer query.
Yes,
You are
my lord. Yes,
representing
my lord.
whom?
That thing has been done before this honorable court, my lord. Page
You are representing whom?
4, 6, and 8 page.
There is
Respondent
no
number-
6, 8.
My lord, may I explain?
My
my
lord, page number
This is
4,
the
6,
second
and
round
8.
of-
Respondent number 6 to
My
9
lord,
is there.
There is.
My lord, kindly see. I am in the body. I am in the body.
My lord, this is the
They
second
may-
round of
they
writ
deleted the
petition.
name from the earlier writ, which was dismissed by
This is
your
the
lordship.
second round of writ petition.
With
The first
to
writ
file
petition.
appraise, and what they did, my lord, they made a copy and paste second application.
Very well, that is their decision whether whom they will make party or not.
My lord,
If
kindly,
you are aggrieved, then make an appropriate application in accordance with law.
my lord, in the body of the writ, my lord, for
I
respondent number 4 and 6. My lord, kindly have a look at page 4.
represented by learned advocate. Next paragraph. From
And
the
there is a case and
made
counter
up,
cases also.
State respondents are represented by learned advocate. Next paragraph. It appears that petitioner is aggrieved by inaction on the part of the concerned police authorities in taking steps in connection with
Tiljala Police Station case number 124.
of 2026. Stop. There is an alternative remedy available to the petitioner under section 175(3) BNSS 2023 by approaching jurisdictional magistrate. In the event appropriate steps are not taken by the concerned police authorities while investigating the case. Stop. In this regard, reliance is placed on the judgment of the Supreme Court reported in 2026 SCC Online SC 798, Sujal Vishwas Attavar and another versus State of Maharashtra and others. Next paragraph, in paragraph 7 of Sujal Vishwas Attavar, it has been succinctly held that even that after it has been succinctly held post registration of FIR, if proper investigation is not conducted, then remedy does not ordinarily lie in invoking writ jurisdiction in the first instance, but party needs to approach within the statutory frame. Next paragraph. Next paragraph. In view of availability of alternative remedy, present writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdictional magistrate in pursuit of remedy.
I'm grateful.
Parties to act on the server copy.
Grateful, my lord.
Next.
Item number 7.
Lordship, I'm for the petitioner.
Yes.
Lordship, kindly pardon me. In page number 5, para number 3, there is written respondent number 6.
He had to mention only one thing.
Please do not make any submission after matter is over. Enough is enough. Yes.
Lordship, in page number 5, para number 3, there is written respondent number 6. Lordship, kindly pardon me. It will be
Paragraph, page number 5.
5, para number 3, Lordship.
Just a minute. Paragraph, not para, paragraph.
Pardon,
Yes. Paragraph 3, yes.
Respondent number 6, it is written, Lordship, it will be respondent number 7. That is clerical mistake from my side.
What is the matter about?
Matter is, Lordship, the petitioner and respondent number 7 was engaged in a business, Porado business. After that, the business dispute arose, and in 2023, petitioner was attacked by respondent
You
number
are praying
7.
for registration of FIR.
Lordship, yes.
Issue.
Your Lordship, I am for the state, Your Lordship. Thank
I
you.
have not called for. This is for your consumption. You are appearing for whom?
Advocate for
We are applying for respondent number 14. We are at
14. 1-4.
1-4. Private respondent number.
Matter is heard in presence of the learned advocates representing petitioner, state respondents, and respondent number 1-4. 14. 14. Next paragraph. By presenting this writ petition, by presenting this writ petition, petitioner has prayed for direction upon the concerned police authorities to register FIR based on complaint lodged. Stop. Next paragraph. There is an alternative remedy available to the petitioner under section 175(3) BNSS 2023 in the event complaint is not transformed into an FIR. Stop. In this regard, reliance is placed on the judgment of Honorable Supreme Court reported in 2007-6 SCC 171, Aliu Padamsi and others versus Union of India and others. Next paragraph. In view of availability of alternative remedy, present writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdiction magistrate in pursuit of remedy. Parties to act on the server copy.
Item number 8.
My lord, I appear for respondent numbers 3 and 4.
But I am for the petitioner, my lord. Affidavit of service, my lord, may be taken on record.
Lordship, may kindly look into the prayers at page 8. I don't know.
So you are dissatisfied with the investigation? There is
Yes,
a
my lord.
delay
Kindly come.
and inaction on the part of the police.
What they have done.
Approach the jurisdictional magistrate.
But the first prayer, my lord, is.
Forum issue.
But the first prayer is not at all applicable. Charge sheet has been submitted.
Charge
Charge
sheet
sheet
has
has
been
been
submitted, but 2 persons who are main accused, they have been discharged.
Then you have a remedy under section.
Let him file an application for 5 years. Further investigation.
Court by filing a writ petition. It was previously 173(8). Now it is
193(9) of the BNSS.
Yes, when charge sheet filed.
My charge sheet.
28th
28th of November 2025. It is annexed at page.
Report. Yes. It is Nagarbajar Police Station case number 10 of 2024.
My lord.
Dated 12th January
2024. Charge sheet submitted on 28th of November 25. Case started against 5 persons. Charge sheet against 3 persons. 2 persons have been discharged from the case. Now, my lord, if they are aggrieved, they can always file an application for further investigation.
Matter is affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, learned advocate representing petitioner submits that petitioner is aggrieved by inaction on the part of police authorities in taking the investigation of Nagarbajar Police Station case number 10 of 2024, dated 12 January 2024, to its logical conclusion. prayer is made for issuance of mandamus directing the police authorities to expedite investigation and submit report. Next paragraph. Learned advocates, you are representing respondent number
3 and 4.
Respondent number 3 and 4 are represented by learned advocate. Next paragraph. Learned advocate representing state respondents has filed a communication dated 27 July 2026 of officer in charge Nagarbajar police station, and same is taken on record. Copy of the communication, copies of said communication are made over to the learned advocates representing the petitioner and respondent numbers 3 and 4. Next paragraph. It is disclosed in the communication that on completing investigation in Nagarbajar police station case number Nagarbajar police station case number 10/2024 dated 12 January 2024, charge sheet dated 28 November 2025 was filed before the jurisdictional magistrate. Stop. Are you aware of, Mr. Mitro, whether cognizance is taken by the court below?
Yes. Yes, it has been taken.
Stop. It is also contended. It is also submitted by on behalf of respondent numbers 3 and 4 that post filing of charge sheet, cognizance of offence is taken by court below. Next slide. Once cognizance is taken by court below, after filing of charge sheet, writ petition is not maintainable since judicial order intervenes in the proceeding. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court.
My lord, I am relying upon my lord one.
Supreme Court reported in 2024 SCC Online SC 5761 within bracket Nita Singh and others versus State of Uttar Pradesh and others. Stop. It needs to be recorded herein that petitioner, that court, it needs to be recorded herein that court is not considering. It needs to be recorded herein. Neither court is considering application. Neither court is considering application under Article 227 of Constitution of India, nor this is an application under Section 482 CRPC / Section 521 BNSS 2020. Stop. Once judicial order intervenes in the proceedings, writ petition is not
My lord, it is 528, my lord.
Yes, 528 I have said.
521, my lord, I heard, but I may be wrong.
No, 528 I have said. Judicial once judicial order intervenes, judicial order intervenes in the proceeding, writ petition is not maintained. Next paragraph. Hence, present writ petition is dismissed. However, this order shall not preclude the petitioner to take steps in accordance with law if so advised. Parties to act on the server.
Grateful, my lord.
Item number 9.
I make clear. In this matter, my lord.
My lord, I am appearing on behalf of private respondent number 4.
Milord, before your lordship rises, Milord. Get production. Let's call the list.
Item number 10. 10, my lord, I appear on behalf of the petitioner, my lord. I serve the copy of the upon the respondent consults. My lord, the petitioner father-in-law, my lord, is originally recorded owner in respect of plot number 307, 3007, 3008, 3046, 3051. The petitioner is belongs to Santal community, my lord. The respondent number 8, my lord, a powerful and very influenced persons, my lord, in the locality, and is using muscle power, my lord. He forcefully
For the respondents. When you have served notice.
my lord, I serve a due serve.
देखिए हमें दाओ तो.
My lord,
No, what you are praying for?
my lord, I paying for, my lord, the respondent number 8, my lord. The take a step is according to law.
Whether any FIR is registered?
No, my lord, I made a complaint, my lord, page my lord 17 P3. Thereafter I made a letter demanding justice, page 22 20. Lord, my land has damaged, my lord. The same land, my lord, is not cultivated. The persons are extraction of black stone in my land without any permission of the authority and me.
Where is your complaint?
My lord, page 17 P3. All authority I made a complaint, my lord, by hand. Page 19. They received.
Mr. Mukherjee, Moyuk Mukherjee, appear in this matter, obtain instruction. Nobody is appearing for the state in spite of service of notice. Issue. Affidavit of service filed on behalf of the petitioner is taken on record stop. In spite of service of notice, respondents are not state respondents are not represented. Next paragraph, Mr. Moyuk Mukherjee, learned advocate, is present in court, who usually represents state respondents. Next paragraph, Mr. Mukherjee is requested to enter appearance on behalf of state respondents. Stop. Learned government figure is requested to regularize engagement of Mr. Mukherjee on behalf of state respondents. Next paragraph, learned advocate for the state is directed to obtain instruction. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 27th August 2020.
Debriefing.
Next.
Copy যদি পারেন. Debriefing.
Item number 11.
Item Your Lordship, led by Mr. Somonag is before his legs, Your Lordship, praying for short passover, Your Lordship.
Yes.
Mr. Somonag, led by Mr. Somonag, praying for short passover, Your Lordship.
Not today.
Wait.
Not today.
Wait.
Item number 12.
Lordship,
Milord, in item 12, Milord, I appear for the petitioner. Milord, I appear for the petitioner.
Yes.
Milord, I was only praying, Milord, if your Lordship may kindly take up this matter on some other day, if it could be, Milord, on the 19th, Milord, subject to the business of the court permitting, Milord.
Yeah, for the state.
I am for the state.
19th.
19th, Milord, subject to your Lordship's.
Well, 19th August. Recorded at the time of Mr. Kishore Dottal and senior advocate representing the petitioner appears on virtual mode. State respondents are represented by Mr. Rajdeep Mojumdar, learned additional advocate general. Next paragraph, on behalf of state respondents, accommodation is prayed for. Stop. Hearing of this matter stands adjourned. list the matter under the same heading on 19th August 2026.
Your Lordship, if the affidavit of service be taken on record.
Affidavit of service filed on behalf of the petitioner is taken on record. Next.
I'm grateful, my lord.
Item number 13.
Item number 13, my lord, I am for the petitioner here. My lord, petitioner made my lord application.
Your Lordship, in this matter, I appear for respondent, private respondent number 15.
Who is for state?
My lord, it is a lawful owner and possession of the schedule mentioned lands, seeking my lord in protection of his possession and my lord enforcement of the subsisting interim order passed by the Honorable Supreme Court as well as the Honorable Tribunal. My lord, I am the member of the Bhumijibi Sangho, my lord, which challenged the constitutional validity of the petitioner under section 14(t)(3). My lord, that is the Honorable Supreme Court several order passed the status quo as regards possession without, my lord, in proceedings initiate but not final order passed.
You are praying for a direction upon the private direction upon the police authorities to take steps which would prevent private respondents from encroaching your land.
Encroaching, yes.
So what police authority will do?
Police authority, my lord, the Supreme Court, my lord, repeatedly says that no third party interest create. My lord, I am approach the BLRO detect the who is my possession.
Then approach the group 1 bench. What police will do? Is it the duty of the police authority to decide the rights of the parties?
Kindly appreciate my police authority, my lord. Direct the.
What is your submission?
Submission, my lord.
Yes.
For that, my lord, my predecessor, my lord, I am appearing, my lord, to private respondent. Respondent number.
Yes. What is your submission?
Before that, before vesting, my lord, my predecessor was the patta holder in one plot. And another plot, he is the recorded owner, and my client's, my lord, he was residing in the said plot of land for long years. That's why that application is not maintained.
Kindly see the Supreme Court order, my lord. Several order passed.
In your matter?
Yes, my lord. Now, my lord, Bhumijibi Sangho. I am a member of the Bhumijibi Sangho, and thereafter, my lord, Honorable Tribunal, my lord, Tribunal. Kindly see page 23. Page 23. Page 33, my lord. Page 33. The liberties granted state Purva Bardhaman granted directly. Page 32. Page 32 to avoid multiplicity.
Where is the order of the Supreme Court? Where is the order of Supreme Court?
Kindly see.
Would be question, my lord, whether he has filed the application before the Supreme Court or not.
29.
Page 29.
29. Page 28, 29.
The 2000 order.
Yes. Thereafter, my lord, several order was passed, my lord. Kindly see. Page, my lord, 30. Vesting order has been passed in respect of the lands member petitioner Sangho who were before the High Court, out of which the present proceeding has then those vesting orders shall not be implemented until further order. That is the 14(t)(3) proceedings, my lord. Thereafter, I approach the Honorable Tribunal. Thereafter, I approach the Honorable Tribunal. Honorable Tribunal passed an order to avoid multiplicity, to avoid the future application, conflicting judicial decision. We are the considered view. The interim order of stay, the impugned order 22nd February 2020 should be passed. Impugned order.
Your contention that vesting order in favor of the petitioner was passed, which is non-est in view of the order passed by the Supreme Court on 17th April.
Yes.
Affidavit of service filed on behalf of the petitioner is taken on record. File your affidavit of service.
Yes.
Next paragraph. Learned advocate representing the petitioner prays for direction upon the concerned police authorities to take steps which would prevent the petitioner, which would prevent private respondents from encroaching land of the petitioner. Stop. It is submitted during course of reliance is also placed on order of the Honorable Supreme Court dated 17th April 2000, passed in special leave to appeal within bracket civil close bracket number 1416/1997. Stop. Next paragraph, learned advocate representing state respondents and
Respondent number, my lord. 10 and 13.
And respondent number 10 and 13 are represented by learned advocates who have opposed this writ petition. And it is contended that the issue involved in this writ petition relates to land dispute. Next paragraph. On perusal of the order of Honorable Supreme Court dated 17th April 2000,
And a recent order also passed.
it appears that
And also, my lord, recent order. Number two.
which was passed on
Well, let's kindly see the recent Supreme Court order.
number 1416 of 1997, referred by Paschim Bongo Rajya Bhumijibi Sangho and another. Lines is placed. Now, it is found that hasting orders issued in respect of lands of members of petitioner Sangho in that special leave to appeal or special leave petition. Special leave to appeal.
I made a party Bhumijibi Sangho member, my lord.
Resolution number 15.
Who were before the High Court in connection with matter out of which special leave to appeal was preferred. Or special leave to appeal arose. Was directed not to give effect. Was directed not to be given effect.
And also, my lord, recent, my lord, one order, recent order was passed by.
Shall not be given effect to call until further. The sentence ta ki holo? was এর আগে একটা comma. It is contended on behalf of petitioner that parta which has been granted in parta which was issued in favor of private respondents was in the teeth of order of the Honorable Supreme Court dated 17th April 2000. Stop. Next, in the event petitioner finds that parta issued in favor of private respondents cannot survive in view of the order of the Honorable Supreme Court. In that event, petitioner needs to approach. In that event, petitioner to take recourse to law. Stop. Police authority is not the authority to decide validity of parta if issued in favor of private respondents. Next paragraph. Hence, present writ petition is not interfered with and same stands dismissed. However, this order shall not preclude the petitioner to take steps in accordance with. Take it back. I have not called for any report.
Madam, kindly see the last.
Next matter.
Lord, item
number 14.
Hold on fast. Wait. Yes.
My lord, I'm praying for a short passover, my lord, and item number 14. I'm for the petitioner.
Next Monday. Next.
I'm good.
At the record and order. At the order. At the time of call, accommodation is paid for on behalf of the petitioner. Hearing of this matter stands adjourned. Stop. List the matter under the same heading on 17th August 2026. However, it is made clear that no further adjournment shall be granted on the next date. Next.
Item number 15.
Sir, I beg for the petitioner.
State respondent.
I am for the KMC matter.
State.
They have part at party.
KMC is not the party.
I'm the state
Yes. I have not called for any report. It is for you. Yes.
The petitioner before Lordship Millard filed a suit for partition. In that partition suit, Millard, the interim order was passed and subsequently final order was passed, directing the parties Millard to maintain.
Final order passed means it was decreed.
No. Final order Millard in respect of Millard injunction application. Millard, the past Millard directing the parties to maintain status quo as regards nature and character of the property in question. Thereafter, Millard, an application under Order 39 Rule 7 was filed. The commissioner was appointed
Under
Order 39 Rule 7 of the CPC for Millard local inspection. Was filed, Millard, commissioner was appointed, Millard, commissioner submitted a report in the civil court. Now, Millard, when this interim order was continuing, Millard, respondent number 5, they are making construction over the property in question. Millard, what they have done, Millard, they filed a writ petition before this honorable court alleging police overaction. Now, when the matter was taken up by your lordship, Millard, they took an adjournment. Now, Millard, that writ petition is hanging or pending before your lordships. Now, what they are doing, Millard, they are making construction. Millard, police is not taking any steps. I, Millard, lodged a complaint to that effect. Look here that they are changing the nature and character of the body in question. Police is saying their writ petition is also pending.
whether it is running in the list.
Yeah, Millard, kindly see, Millard, page, I have paragraph 7, page 5. I have
No, whether the writ petition is running in the list.
running in the list. Not running, not in the list, Millard. But kindly have a look, Millard, one paragraph and so to lordship, page 5.
What was the order passed in that writ petition?
No order was passed.
Simply action.
Well, they simply asked for an adjournment.
No, if it is filed before me, it must have come before.
Yes, they.
So what was the order passed?
Order is, my lord, they prayed for time, matter was adjourned. Bas.
My lord, on that score, my lord, your lordship, my lord, change of my lord, the state advocate matter was my lord, called on by your lordship. Thereafter, matter was adjourned and take instruction. That was the my lord, last order.
Now, my lord, the problem is, my lord,
is it appearing in the list?
No, there is no.
Yeah, it can be tagged with that order also, with that petition. My lord, I have given the description.
The petitioner.
I am the petitioner.
Page 5, paragraph 7, my lord, I have stated. But my innocuous prayer, my lord, that let the civil court order be implemented by the police. My lord, this is the final form. my
No,
lord.
civil court order, if it is there under order 39 rule on 1 and 2. In that event, if it is violated, if you have to file an application under order 39 rule 2A, rate with 151.
Problem is, my lord, your lordship, my lord, kindly visualize the situation. They filed an writ petition alleging police overaction.
Where is the order?
My lord, kindly see, my lord, the order passed, my lord, by the civil court, my lord, appearing at page 21. Page 21. My lord, last paragraph.
No. Final order.
Final.
Yes, very good.
I'm just pressing last. Having heard the plaintiff side and perusing the case record, it appears the
It
suit.
says come to page 22. Parties are
Yes.
directed to maintain status quo
Yes.
in respect of
Yes,
the nature and character of the suit property.
Yes. Now, my lord, after that, my lord, kindly have a look, my lord, one.
Mr. Tewari, no right accrued in favor of the petitioner, even at the interim stage. Status quo order is meaningless order.
No, my lord,
Without defining
who is
the right of the parties in respect of the suit property. There is a judgment of Justice Dotto in Soumitra Bandyopadhyay and another.
That judgment, my lord, kindly, my lord, have a look, my lord. I may just place that judgment also. But before that, my lord, kindly have a look, my lord, PR Muralidharan once.
Yes.
PR Muralidharan once.
Yes, this was considered in.
Yes. The PR Muralidharan said, my lord, if even it an interrogatory stage.
Yes, if any decision is taken in an identical situation, it was before the coordinate bench in Soumitra Bandyopadhyay and another, where same set of facts, order of status quo, and court held that this is a meaningless vague order. Status quo order is nothing.
No, my lord, kindly visualize the court has said, my lord, the status quo in respect of the nature and character of the suit property till the disposal.
Unless and until you define that what is status quo, what is the position at the same time, it does not bear any meaning.
No, my lord, kindly have a look, my lord. In that case, my lord, I have to read out the entire order.
I have seen the order. Please don't waste court's time by
Kindly see, my lord, 2 pages, my lord, page 42 and page 43, what they are doing. Kindly see, my lord. The order of the court is to be respected, my lord, by any means whatsoever.
Yes, sure.
But may I just, so far as my lord, your lordship, my lord, Justice Dotto's judgment, my lord, may I just place it, my lord, kindly have a look, kindly give me, my lord, 2 minutes, my lord. My lord, kindly, my lord.
By presenting affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. By presenting this writ petition, I will also rely upon Justice Dotto's order.
My lord, I'm just, that's why, my lord, kindly give me, my lord, 2 minutes time, my lord.
By presenting
Justice Dotto, only on different aspect, my lord.
Prayer is made.
There is one identity, my lord.
Prayer is
Justice
made
Dotto's
for
judgment, my lord, is based on identity order.
For
final disposal of.
For implementation, yes, that was identity
Yes.
injunction.
Here-
Ex parte identity order.
Yes,
In your case, it was a final.
Finally disposed of.
Even then, you will find in that judgment, that's why I am not permitting you to read it out. You will find it in that judgment that it was in connection with status quo order.
Yes, I have
And
seen
the
it.
status quo order without defining the rights of the parties in connection with the suit property is vague order.
May I just submit one?
Yes,
thing?
sorry.
Kindly, yes, my lord, I know that. Kindly, my lord, 1 minute. In a partition suit, your lordship, my lord, kindly visualize this.
Petitioner, by presenting this writ petition, petitioner has prayed for issuance of mandamus, directing the police authorities to take steps for implementation of the order dated for implementation of ad interim injunction dated 2nd June 2025, passed in title suit number 69 of 2025. Stop. It is submitted that violating order dated 2nd June 2025, private respondent.
Only singular.
Private respondent is making construction changing nature and character of the suit property, which is contrary to the direction as contained in said order dated 2nd May 2025. Next paragraph, state respondents and private respondent number.
Right.
Which respondent? Private respondent and respondent number 5 are
Case 1 of 5.
by learned advocate. Next paragraph. On perusal of order dated 2nd May 2025, 2nd June 2025, it is found that parties to the suit within bracket TS 69 of 2025 close bracket were directed to maintain status quo in respect of nature and character of suit property till disposal of the suit. Stop.
This order was also
So
affirmed by the
this is a
district.
final order passed on conclusion on final order passed on an application under order 39 rule 1 and 2 of CPC, but petitioner has a remedy, alternative remedy under section under order 39 rule 2 capital A read with section 151 CPC. Stop. Moreover, nature of order which was passed by the civil court is directing the parties to the suit to maintain status quo. Stop. Status quo order without defining right of the parties over the suit property does not crystallize even at the interim stage, or does not confer confer right upon the parties even at the interim stage. Stop. In other words, in view of order passed by civil court on 2nd June 2025. Now, in other words, rights of the parties to the suit are not crystallized on the strength of said order dated 2nd June 2026, directing the parties to maintain status quo. Stop. If right of the parties are not crystallized, if right of the parties even at the interim stage is not crystallized, police authorities ought not to be directed to take steps for implementation of the order. Stop. In this regard, reliance is placed on the judgment of a coordinate bench reported in 2016 SCC Online Calcutta 2683 within bracket Soumitra Bandyopadhyay and another versus State of West Bengal and others. Next paragraph, before parting with, it needs to be recorded that petitioner has an alternative remedy to approach civil court under order 39 rule 2 capital A read with section 151 CPC. If it is found that order passed under order 39 rule 1 and 2 is violated. Next paragraph. Hence, present writ petition is not dismissed. However, this order shall not preclude the petitioner to approach civil court in pursuit of remedy. Parties to act on the server.
So far as writ petition pending before your lord, kindly consider that.
And you will find in Soumitra Bandyopadhyay, in your case, it is not similar case which was considered by the coordinate bench in Soumitra Bandyopadhyay.
Yes, I have seen.
In Soumitra Bandyopadhyay, after ad interim order was passed, an application was filed under order 39 rule 2A read with 151, and there was an order for implementation of the order, and subsequently the writ petition was filed seeking direction upon the police authorities to take steps. But in the present case, without availing of the remedy which is open to you in terms of relevant provisions of CPC, straightaway you have approached this.
Well, only one thing why I have
that is impermissible.
The other writ petition is pending, that is hanging on my shoulder, my lord. That writ petition is pending. Police is not doing anything. This is the problem. Otherwise, I would not have approached. Kindly see paragraph one. So far as this,
to that extent,
one observation. Kindly direct the police to maintain the peace and tranquility. One observation will suffice. Otherwise, what they are doing, Lord, by keeping this writ petition pending, Lord, they are.
Next paragraph at a line.
39 for application.
Indicate particulars of that writ petition.
Yes. WPA 9834 of 2026.
9834.
Yes.
Of
2026. 2026.
It further appears from the submissions made on behalf of petitioner and respondent number 5.
Right.
Respondent number 5 that a writ petition being WPA 9834 of 2026 is pending concerning same property, and that writ petition is preferred by the respondent number 5.
Alleging police operation.
It is submitted on behalf of petitioner that due to pendency of this writ petition, police authorities unable to take steps. Stop. Next paragraph. It is clarified that pendency of writ petition being WPA of 2026 shall not preclude the petitioner to take steps in accordance with.
My lord, there is another observation. They are going to the my lord, executive magistrate. The executive magistrate set aside the order of the my lord, 144.
Item number 16.
May it pleases your lordship, I am appearing for the petition in this matter.
For the claims,
I am appearing for Kolkata Municipal Corporation, your lordship.
My lord, affidavit.
Appearing for Kolkata Municipal Corporation.
My lord, may I place my case?
Item number.
So you are seeking a direction upon the police authorities
I'm
for taking steps so that your right of the over the property can be preserved and you can have peaceful possession over the property in question.
my lord.
That is the sum and substance of your case. Now, in that event, you have to approach the civil court.
Lordship.
Yes, your lordship.
Petition, if court directs the police authorities to take steps in order to facilitate the petitioner to have peaceful possession or seamless possession over the property in question, then it is a roundabout way to get an order from the writ court, which is not within the domain of writ court, because you are representing private respondents. Kolkata Municipal Corporations. Now, whether the private respondents have been made parties.
Yes, your lordship.
Therefore, they are required to be heard and your right has to be asserted before the civil court.
My lord.
Why the writ court will issue a mandamus directing the police authority?
My
to
lord,
take steps?
may I place my case and explain what is the scenario?
Very
is?
nutshell in it.
Yes, my lord. My lord, I am a lawful occupant and I have been residing in this premise which is mentioned in paragraph number 2. I have been residing there since my birth, since 1967. I have annexed the documents which state my possession, your lordship. My lord, if my lord may come to page number 42, running page number 42, it is a legal notice which is sent by the private respondents to my brother. They have not sent any legal notice to me, and I have a reasonable apprehension that they will forcefully dispossess me from that
So
property,
it is your
my lord.
apprehension.
My lord, I am a cancer patient. I am in my 4th stage. I am actually going through a lot of my medical
No, but
and
on mere apprehension, whether the writ court can pass an order anticipating some steps shall be taken affecting right of the petitioner.
my lord, my family member has received a legal notice, and in that legal notice, they are describing me as an illegal occupier. And
And you have to challenge that notice before the bench taking corporation matters, group
my
5
lord,
matters.
my lord,
Civil
may
in
I-
nature.
May I
Eviction
submit, my lord?
notice
I am the petitioner in this case. May I submit my case, my lord? My lord, the illegal notice has not been sent to me. It has been sent to my brother, my lord. If it has been sent to me, I would have challenged that same in the appropriate legal authority, my lord.
Find that illegal notice which is sent to your brother will affect your right also. You have a right to challenge it.
My lord, right now, as I stated earlier, my lord, I am in my 4th stage of cancer and
behalf of the petitioner is taken on record. Next paragraph. By presenting this writ petition, prayer is made for issuance of mandamus, directing the police authorities.
my
to
lord,
take
my humble prayer is
which
that
would
I should not be
facilitate the
forcefully
petitioner to have
I should
peaceful
not be
possession
forcefully
over the
dispossessed from
land
my
in
property, my lord.
Stop. It is also submitted that petitioner apprehends based on notice issued by Kolkata Municipal Corporation. Petitioner might be affected. Next paragraph. State.
KMC have not issued.
Who has issued?
Private respondent have issued. It is an eviction notice, your lordship.
কি বলছিল?
It has been issued to my family member, my brother, my lord.
Issued by the private respondents to the brother of the petitioner. Petitioner might be evicted from the premises in question. Next paragraph, state respondents and Kolkata
We are Kolkata Municipal.
and he's for the state. you
No,
are
no,
for the
he is appearing with me.
In this
Oh,
matter,
Kolkata Municipal Corporation is represented by learned advocate. However, state respondents and private respondents are not represented. Next paragraph, from the case made out in this petition, it appears petitioner is trying to assert his right over the property in question so that in future petitioner may not be evicted.
My lord.
Stop. Having considered the case made out in this petition, it is found that the issue involved is civil in nature, requiring the petitioner to approach appropriate forum. Stop. Police authority is not the appropriate authority to decide right of the petitioner over the premises in question.
My lord,
Next paragraph. Hence, present writ petition is not interfered with and same stands
Your Lordship,
dismissed.
Your Lordship.
However, this order shall not preclude the
Your
petitioner
lordship, even if
to take steps in accordance with law if so advised.
your
Next
lordship,
matter.
even if I am a trespasser, I should not be forcefully disposed as my lord.
Next matter.
Great.
Item number 17.
I appear for the state.
This is a matter regarding my lord. My shop was forcefully
You are for the state.
acquired, my lord, by some person. My lord. I sent all the responded, my lord.
Whether those persons have been made parties.
Yes, my lord. There's
Have you served notice upon
Yes,
them?
my lord. Delivered. Because, my lord, you should kindly come to my trade license, my lord. That is my father property, my lord. Page 15, my lord. P1.
Whether any FIR is registered.
Yes, my lord.
FIR is registered.
FIR was registered below initially.
But no steps taken, my
No,
lord.
no steps has been taken.
Tell me whether any FIR is registered or not. If FIR is
Yes, my
registered,
lord. FIR has been registered.
if FIR is registered, give me particulars of that FIR.
Under section.
হ্যাঁ নাম্বারটা কত আছে
নাম্বারটা আছে এখানে
কত আছে
P29 PS case number 87 of 2026.
P29
87 of
Where is your complaint?
complaint, my lord. Firstly, my lord, that is, my lord, P2 page 20, my lord. That is my mother complaint. That is dated 5th of January 2025. And subsequently, my lord, next page, my lord, my deceased brother, my lord. That is next page, my lord, 23rd of June 2026. And then last complaint, my lord, that is 8th of July 2026. Several complaint has been made by the
Just a minute. co-op is closed for last 1.5 months.
This is untruly, my lord. False, my lord. Because, my lord, you have to kindly see the report, my lord. This is closed for the long 6 months, my lord. This is my property, my lord.
Is filed on behalf of the petitioner. Is
That
written on
report, my lord, this is a baseless report. Because, my lord,
behalf of
you should kindly the report, my lord.
that in spite of lodging complaint, necessary steps are not being taken by the concerned police authorities for initiating a criminal prosecution and to investigate case. Stop. Petitioner prays for issuance of mandamus directing the concerned police authorities to investigate case by registering FIR. Next paragraph, learned advocate representing state respondents has filed a communication dated 6th August 2026 of Inspector in Charge Balurghat Police Station, Dokhin Dinajpur, and same is taken on record. Stop. Copy of the communication dated 6th August 2026 is made over to the learned advocate representing the petition. Next paragraph, it is disclosed in the communication that till date no FIR is registered in view registered after preliminary steps were taken by the police authorities. Next paragraph. If petitioner is aggrieved by inaction on the part of the concerned police authorities in that event, petitioner needs to approach jurisdictional magistrate under section 175(3) BNSS 2023. Reed court is not an appropriate forum for ventilating grievance of inaction of the police authorities. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2026 SCC Online SC, page 798 within bracket Sujal Bishwas Attavar and another versus State of Maharashtra and others. Next paragraph. Hence, present writ petition is not interfered with and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdictional magistrate in pursuit of remedy. Parties to act on the server.
One and interest may be taken into consideration, my lord. Under 19(1)(g), my lord, that is right to business, my lord. That is
next matter.
My lord, kindly consider, my lord.
Item number 18.
For the risk.
This is a serious case, my lord. My wife has been, my lord, brutally, my lord, injured, my lord. You should kindly come to, my lord, my complaint, my lord. Section is very simple, my lord. That is also, my lord, objectionable under law, my lord.
How you have served upon private respondents?
Private respondent, I have served, my lord.
When served? Find it out when served.
Delivered, my lord.
When?
It was, my lord,
there are
5th of my lord,
August.
This is a delivery report, my lord.
Of August.
Top of the, my lord. Top, my lord. Top 5th of August. Just I check.
No, this was sent to Director General of Police.
Private was not there.
You need to tally the consignment number. There are 3 postal slips. One is sent to Director General of Police, another is District Magistrate, and another is Superintendent of Police. Where is the postal slip? So far,
Sorry,
service upon the private respondents are concerned.
I don't got
Extensive.
You are not a new entrant in this profession.
that is true.
So
Sorry.
court has to rely somewhere, somehow.
Yes, ma'am.
If this court is required to scrutinize
Yes,
your
that is-
affidavit
that
of
is-
service,
yes,
then it's difficult for this court.
I am extremely
call to run this court.
extremely, my lord. Sorry.
Now you are saying,
Because
I could understand that a junior
Yes.
is appearing before this
yes, I
court.
am messaging from
With responsibility, you are making submission that it was sent upon the private respondents on 5th of August. Court will never believe you. There are three postal slips. All are there are
It
three
was
postal
sent.
slips.
My according to my
There are
information,
three
my lord,
postal slips. All are addressed to police authorities.
sorry, man. Sorry, man. I'm extremely sorry. It's my mistake, my lord. Sorry.
Take it back. ফেরত দিয়ে দাও। এসো। At the time of call, learned advocate representing the petitioner prays for accommodation to serve notice upon respondent numbers 6, 7, and 8. However, state respondents are represented here for the state.
Yes, my lord.
However, state respondents are represented by learned advocate. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon non-appearing respondents, respondents by fortnight from date and file affidavit of service on the next date. List the matter under the heading motion non-service in the monthly combined list of September 2026.
The report may be, my lord.
Nothing. Next matter.
Item number 19. My lord, I appear on behalf of the petitioners, my lord, my affidavit of service. Respondent number 10. My lord, if my lord comes to page number 24, my lord.
I'm for the state, my lord. I'm for the respondent number 10.
My complaint, I had made a complaint before the police authorities dated 20th July 2026. Thereby, my lord, my allegation was that the private respondents are illegally cutting trees.
You are praying for registration of FIR.
My lord, subsequently, my lord, prayer B, my lord, if
Whether FIR is registered, who is for the state?
Has been, my lord. I have the
Yes.
Should kindly, my lord, have a look. The FIR is also attached, my lord.
After filing of this writ petition.
No. Prior to that, my lord. Prior
My
to
lord,
that.
there is an analogous matter, my lord.
This is Bolpur PS case number 227-20 dated 14 September 2020.
Lord should be
14
fine.
September 2020.
No, my lord. There's another, my lord.
There are two
FIRs.
two FIRs, my lord.
One was there prior to, my lord. There's one.
One is dated 29 July 2026.
Absolutely, my lord. This is the one.
339-2026 dated 29 July 2026.
Absolutely, my lord. And investigation is going on, my lord.
Yes, it is after filing of this writ petition. Writ petition was filed on 27 July. So your grievance is redressed.
My lord, there is another writ petition pending, my lord.
Affidavit of service filed on behalf of the petitioner is taken on record. It is found from record that present writ petition is instituted seeking direction upon the concerned police authorities to register FIR based on complaint lodged. Stop. Next paragraph. Learned advocate representing state respondents has filed a communication dated 6th August 2026 of Inspector in Charge, Bolpur Police Station, and same is taken on record. Copy of the said communication dated 6th August 2026 is made over to the learned advocate representing petitioners. We are for the private respondents. Respondent number
10.
is made over to the copies are made over to the learned advocates representing petitioner and respondent number 10. 10. Next paragraph. It is disclosed in the communication dated. It is disclosed in the said communication that based on complaint lodged, a criminal prosecution being based on complaint lodged, an FIR was registered being Bolpur Police Station case number 339/26 dated 29 July 2026 and investigation has commenced. Stop. In view of steps taken by the police authorities, no further order need to be passed on this writ petition and same stands disposed of. Next paragraph. However, this order shall not preclude the petitioner to approach jurisdiction magistrate in accordance with law if occasion so arises. parties to act on the server copy. Next. Publish.
Okay.
Item number 20.
20, my lord, I am the state private response. Item number 20, I am for the petition.
Yes.
My lord, I'll take your lordships through certain civil court orders, but then my prayer is not with regards to the possession. My lord, may kindly see.
But you are seeking direction for registering FIR.
Yes.
Prayer A.
And inquiry. I'll tell you, lordship.
Inquiry is to be conducted after registration of FIR.
The inquiry under disciplinary proceeding against the erring police officers. I'll tell you, lordships, why. Lord, kindly sees page 44 for once. Apparently, it might seem that I'm interfering, I'm invoking this jurisdiction in a civil courts matter, which is not the case. Page 44, my lord, I have secured an order where there was a direction of the civil court not to dispossess me. That was absolutely between me and the private respondents. Police had got no role to play with it. Thereafter, my lord, a series of, and this order was communicated.
You are the defendant therein.
I was the plaintiff in the title suit. But I am not with regards to dispossession here. Page 46, my lords, I have intimated the order out of my own volition to the officer in charge that this order has been passed. Subsequently, my lord, a series of 144, 107 proceeding by me and against me by the defendants. Thereafter, my lords, the averments, my lord, kindly seize my averments from paragraph number 9 and onwards in my writ petition. On 14/7, a police officer comes to my place of business. He takes me to the police station. He detains me throughout the day at the police station without informing me my grounds of arrest. He takes me to he does not produce me before the magistrate. He takes me to the local hospital. I have placed an RTI before the authority, hospital authority. They have replied to that effect. I'll produce before your lordships. And at night at 8:30 p.m. they say you may go. I am before your lordships for this illegal detention. I am before your lordships.
Prayer to the extent.
That is exactly why I have made one complaint. Lord, kindly seize my complaint annexed at P8.
Page?
That is at page 52. And I have been beaten up inside the police station. Page number 52 is my complaint against the erring police officers. And page number 54 and onwards, this is the prayer. I've prayed for the CCTV footage to be preserved. I've prayed for an inquiry against the police officers, so on and so forth.
That is your complaint, page 52.
Page 52 is my complaint and the prayer. Yes.
Yes. Whether any case
My
has
lord,
been
actually submission made by the by my learned friend with my lord is not matching with the report. My lord, the police concerned.
show me any notice
Lordship,
directing the requesting the petitioner to appear before the police authority.
Lordship,
Show me.
Lordship, kindly see this.
I am asking you, show me the notice.
There is no
Whether
such-
any notice
no
under
such
any
notice.
provisions of BNSS,
No such notice.
then
is
how
there.
the petitioner was detained in
My
police
lord,
station?
actually during patrolling, my lord, these gentleman was found to creating nuisance, and that's why he has been taken in custody.
Nobody will believe this. There is a civil suit pending. Petitioner has been able to obtain an order. Don't make any concocted story.
Lordship,
I can understand that in connection with the criminal proceedings, a notice was issued under 35(3) or under section 94 or under section 180, and petitioner was asked to appear before the investigating officer. Otherwise, you cannot. I will direct the SP to initiate disciplinary proceeding against the errant police official.
No, my lord.
Show me what are the particulars based on which. No, not this report. Show me the particulars based on which petitioner was directed to appear before the police station.
Lordship, then what I am saying, my lord, let it be submitted in the form of affidavit.
Nothing. First, show me that how police authority can ask the petitioner to appear before him. On what basis? What are the materials before the police authority?
My lord, he
Otherwise, he will be in trouble, I am telling you. I'll direct the SP or higher authorities to initiate proceedings against him.
So, Lordship, kindly record our submission. I am submitting this.
No, first satisfy me that what are the materials before the police authority directing the petitioner to appear before him.
There is no such whisper.
Then
actually, what they have written, this gentleman was found that he is creating nuisance, and he has been picked up and kept in the custody.
Can it be done?
My lord,
how it can be done?
If
a shop owner fighting a civil suit, obtain an order, and he will be picked up by the police authority in one fine morning.
There is a dispute, tenancy dispute, my lord. So far, this
And
report,
that's why the tenant will be picked up.
No.
So how petitioner was taken? Why petitioner was taken to police custody or the police station and detained from 6:30 to 8:30, 6:30 a.m. to 8:30 p.m.
No, this report.
Then this report is meaningless report. Don't file it. I have not asked to submit a report. Now you have to satisfy this court that why this was done.
Then, my lord, further instructions is required. Lordship, kindly grant me at least 7 days time.
Do one thing. Serve notice upon Mr. Surjonil Das, learned additional government leader. And I will request him to appear in this matter along with him.
Grateful, man.
Your only one thing, since private, there is no grievance against the private
You
respondent.
are the defendant.
Yes, my lord. So, my lord,
You are not
kindly
required to
expunge
make any
us.
submission.
Kindly expunge
Police
us.
has to no. Police not at all. Police has to explain his conduct.
Let them explain. I have nothing to say.
My lord,
We are
may I just
unnecessarily
place
making
one
prayer
document
At
on
this stage, Mr. Chatterjee, I will not.
I will be only a listener between both of them.
Learned advocate to expunge your name. There might be certain leads in view of pending.
If that comes up in
view of
investigation.
pending criminal proceedings. Not at this stage.
Very well.
Yes.
Because I will be only listening between
This
the
will be
petitioner
taken
and
on
the
record.
state authorities.
This is where I was taken to
And
the
Milord,
hospital for a medical checkup.
Milord, since Milord is not questioning Milord
Whether
position,
the errant police officer has been made party by name.
Errant police officers have been
Probably
made party by name,
And,
but they are
took
evading,
you
sir.
to police station.
My lord?
Who had picked you up and took to
Yes.
and
Yes,
took you
they
to
have
police
been.
station?
They have been. My lord, that's from respondent number 6 to respondent number 8.
What is his designation? Respondent number 6.
My lord, I have written that as an arresting officer.
the only thing Milord,
Parakat Mandi is the officer in charge.
Filed on
Milord,
behalf of
only
the
one
petitioners.
one thing, Milord. Prayer D, since he has fairly submitted in the with respect to the civil issue, Milord D, and E, my lord, is covered up. My lord, so this D and E may be, my lord, recorded, he is not pressing for. Otherwise, I have nothing to make submissions.
Very well. Let us have an appropriate report from the police authority. and
Yes,
let
yes,
us-
yes. To that, I cannot even say any word.
Who is the persons behind? That
Yes,
needs
yes.
to be ascertained, Mr. Chatterjee.
Yes, yes.
Yes. So at this stage, don't open your mouth too wide. It is better to give.
No, he has fairly submitted. There is a civil dispute, possession, disposition
can
to
be done.
court.
And if there is no criminal proceeding pending against the petitioner,
No, if that is so, my lord, then
and
police
I
has to
can
give an
understand that
explanation.
in a criminal prosecution,
No, absolutely.
petitioner is found to be a
Police
witness.
cannot go just pick up one person and
Then a notice
detain.
can be issued, and that has to
Absolutely.
be pursuant to notice.
Absolutely. Yes, so, my lord, I have nothing to do, my lord, here. Let them explain their conduct.
Affidavit of service, file your affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. It is alleged by the learned advocate representing the petitioner that on 14 July 2026, incident happened on 14 July. You were taken to police station.
Police station, yes.
On 14
And,
July 2026,
my lord, may I?
suddenly petitioner was forcibly taken to Garifa police outpost.
Alishahar police station.
Garifa police, you were taken to
Garifa out.
Garifa police outpost under Halishore police station and was detained right up to 8:30 p.m. at night. Stop. It is submitted that such detention or presence of the petitioner, such detention and presence of the petitioner in police station is not in connection with any criminal prosecution, neither any notice was issued under relevant provisions of BNSS 2023. Stop. Petitioner prays for direction upon the concerned police authorities to initiate disciplinary proceeding against errant police officer being errant ERRANT ভুলভাল বানান লিখবে না errant police officer being respondent number 6. Next paragraph.
Respondent number 6 to all of them were there. Respondent number 6 to 8.
Then who is representing? You are representing whom?
My lord, 9, my lord.
9.
Private respondent.
Respondent number 6, 7. Respondent numbers 6, 7, and 8.
My lord, may I just interrupt?
Next paragraph. Learned advocate representing state respondents is unable to satisfy the query of this court as to why petitioner was taken to police station on 14 July 2026. Stop. Next paragraph. Learned advocate representing the petitioner is directed to serve notice upon Mr. Surjanil Das, learned additional government pleader, who usually represents state respondent. Now, Surjanil Das, learned additional government pleader, by tomorrow. Stop. Mr. Das is requested to represent state respondents along with the learned advocate representing on behalf of state respondents. Learned government pleader is requested to regularize engagement of Mr. Surjanil Das, learned advocate. Stop. Next paragraph. Officer in charge, Halishore Police Station being respondent number 5, is directed to submit a report by 10 days disclosing as to why petitioner was taken to police station.
Lord, officer in charge himself is one of the perpetrators.
We will let him first respond. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 2nd September 2026.
Lord, one more submission, since my lord has recorded my submissions, I have also said that there has been police abuse, physical abuse inside the police station. That's why I have prayed for securing the CCTV footages. And for which a medical has also been done.
Medical?
A medical report. I mean, I was taken to the local police station, but it's in the awareness of my writ petition that I was intimidated not to say that I was under arrest.
At 6:30, you were taken to hospital.
Yes, I was taken to hospital.
Noihati State General Hospital.
Noihati State General Hospital.
ওখানটা কি বলছি? হ্যাঁ। Petitioner, it is also alleged, it is also alleged that petitioner was physically abused, as a result whereof he was taken to Noihati State General Hospital on same date for administering treatment. আরেকটা জিনিস লিখে দাও, a civil suit or a suit being title suit number 502 of 20 a title suit being number 502 of 2026 is instituted was instituted by the petitioner and in connection therewith order dated 9 July 2026 was passed by Civil Judge Junior Division First Court, thereby restraining defendant from dispossessing the plaintiff from the suit property without due process of law. Stop. Such order was passed for a limited period, that is till 7th August 2026.
May that CCTV be preserved, because otherwise they might have a storage capacity of 15 days.
Grateful. Third notice upon Mr. Das.
Great. I'll do.
By tomorrow. Yes. Call other matters.
Item number 105.
সিক্স কালকের ম্যাটারটা যেটা দেখে উঠে গেল
মিতা আছে
Very senior. My lord, yesterday we also informed my lord
same matter.
had a call. No, phone বলেছি কথা হচ্ছে বলো লিফটে নেই তো লিফটে আছে তো কোয়ালিফিকেশন যাচাই করতে নাকি আমাদের মামাদের থাকা পুলিশ ভেরিফিকেশন আমাদের দিয়ে দিয়েছে পুলিশ ভেরিফিকেশন হ্যাঁ দিয়েছে তো আমরা দিয়ে দিয়েছি সিল কভারে দিয়েছি না অলরেডি পুলিশ ভেরিফিকেশন রিপোর্ট যেখানে আসছে না কেন? দাঁড়াবেন অ্যাপিয়ার করে। আরে আমরা তো অলরেডি কমপ্লাই করে গেছি।
এসো।
হয়ে গেছে, ঠিক আছে? আগে হয়, কাজ পরে হয়।
At the time of call, petitioner is not represented and no accommodation is paid for. Similar
মাথা চুল সব উঠে যাচ্ছে, মাথা চুল তো সব উঠে যাচ্ছে। যে তো কেস খাবে, তো খাবে, কি দরকার? কম্পেনসেশন চেয়েছি।
petitioner was also not represented, similar to Keredo. Petitioner was also not represented previously on 27th July 2026.
আছিস আজকে আমার সঙ্গে?
Next paragraph. However, state respondents are represented by learned advocate. Next paragraph. By presenting this writ petition, prayer is made for issuance of mandamus, thereby directing concerned police authorities to provide police verification report which would facilitate the petitioner to get job on compassionate ground. In Department of Agriculture, Government of Islam. Next paragraph. Petitioner's husband was an employee who died in harness. Consequently, petitioner was selected for being appointed on compassionate ground. However, prior to appointment, petitioner is required to submit police verification report, comma. Since such police verification report was not issued to the petitioner, present writ petition is preferred, seeking direction upon the concerned police authorities. Next paragraph. Superintendent of Police, DIB, Bongao Police District, Vide, memo dated 24th June 2026, has disclosed that two criminal prosecutions are pending against the petitioner. Two following criminal prosecutions are pending against the petitioner. One, Gaigata PS Police Station case number 643/23 dated 18 June 2023.
That is 6349. 6349.
643. 6343. Gaigata Police Station case number 634/2023 dated 16 June 2023, rightly pointed out. Say 18 June 2023, semicolon. 2, Gaigata PS case number 147/25 dated 16th February 2025. Next paragraph. In view of pendency of aforesaid criminal proceedings, direction upon the concerned police authorities to issue police verification reports is not warranted. Next paragraph. Hence, present writ petition is dismissed. However, this order shall not preclude the petitioner to take steps in accordance with law if so advised. Next.
Item number 106. Yes, my lord, for the state, my lord. On last occasion,
petitioner.
my lord was pleased to direct me to file a further report regarding the effort has been given by the police authority to search out the missing person, my lord. So I am handing over the report. Aaj wo get the
Something they fixed. আচ্ছা এই তো মার্গারিতে গেলে
Yes, report.
Yes, I have handed over the report. Police has taken all
Not
the,
detected, not traced out.
not
police has taken all the steps.
কেটে দাও ফোনটা কেটে দাও
এসো।
হয়ে গেছে
Pursuant to the order dated 2nd July 2026.
বলছি
Further,
my lordship
a report,
if efforts may be more to trace the missing person,
yes,
if efforts can be made more to trace the missing person,
papers,
efforts can be made more, my lordship, to trace the missing person.
what?
More effort.
More efforts to, yes,
Yes,
yes.
I have, but how long this writ petition will be kept pending?
Okay, my lordship.
হ্যাঁ, কি বলছিলাম? A report dated a report is filed. A report dated 10th August 2026 of officer in charge Noapara Police Station is filed and same is taken on record. Copy of the said report dated 10th August 2026 is made over to the learned advocate representing the petitioner. Next paragraph.
চোদ্দই যাবো তার আগে 18 যাবো 33 হচ্ছে
Report discloses certain steps taken by the police authorities to trace out missing person. IMEI sub capital IMEI based searching was also made to track mobile set of the petitioner. Mobile handset of petitioner. It was found that mobile number continues to remain switched off. Stop. Next one. This court expects that even after disposal of this writ petition, endeavor shall be made to trace out missing person. Next paragraph. This court finds that no purpose would be subserved to keep this writ petition pending. Stop. Writ petition stands disposed of. Parties to act on the server.
My lordship, if CBI can be here to
Next matter.
Next matter. Item number 107.
In item number 107, I am appealing for the petitioner, my lord. That this matter pertains to the civil property dispute, my lord. Due to the dispute arising between the two brothers, my lord, petitioner is the brother and the private is
notice. This one was 7 and 8.
Yes.
By 23rd June. Where is the notice?
After your lordship direction, I have tried to serve, but the endorsement is insufficient address. The address which we have available to us, my lord, that I have tried to serve, my lord, but it is again come as insufficient address, my lord. Your lordship kindly see.
The service is not complete.
No, not yet effected.
Registration of FIR.
You are praying for registration of FIR.
Yes, ma'am.
So whether the FIR is registered?
No, not.
Why not?
Because one NCR case has been registered. Case counter case. They are brothers in relations.
Approach the appropriate food.
Yes.
Yes. Matter is taken up for consideration in presence of learned advocates representing the petitioner and state respondents. A case is respondent. Stop. It is found that petitioner has approached this court seeking direction upon the concerned police authorities to register FIR based on complaint lodged. According to petitioner, there is inaction on the part of the concerned police authorities in taking steps. Next fact. There is an alternative remedy available to the petitioner under section 175(3) BNSS 2023 if complaint of petitioner is not transformed into FIR. Next paragraph. In this regard, reliance is placed on the judgment of the Supreme Court reported in 2007-6 SCC 171, Aliu Padamsi and others versus Union of India and others. Next paragraph. In view of availability of alternative remedy, present writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdiction magistrate in pursuit of parties to act on this on server copy.
That affidavit of service may be kept on.
Yes, affidavit of service filed on behalf of the petitioner is taken on record.
May I get to the report which
I have not relied upon that.
Yes.
Item number 108.
108, Lordship, for the petitioner, Lordship. The petitioner before your Lordship is the sitting councillor of Barrackpur Municipality, Lordship. What happened is that on the day of election, that is on the results of the election, that is on 4th May 2000. May I proceed?
Notice
has been served, Lordship.
upon the respondents,
Yes,
non-appearing respondents.
Firstly, this notice, the first affidavit service was given for when there was the private respondent didn't receive the copy. Thereafter, again one notice was given upon direction of this court, and they have received it, Lordship. The crux of
When received?
when received. This notice has been delivered. The petition has been delivered on 16/6/2026, Lordship. The crux of the matter is that on the day of the result of the election, that is on 4th May 2026, this private respondent, being a leader of a member of the ruling party, came to our house with some few men and agents and threatened us with dire consequences, hurled abusive language to us, and created such a situation that me and my two minor children, with my husband and other family members, had to leave our house in one cloth in a single night, Lordship. Thereafter, we approached the police station regarding the said matter. They have not taken any action. On the next one, that is on
Now you are staying where?
Yes, Your Lordship. Now we don't have my own place, Lordship. Sometimes we are residing at relatives' house, sometimes some other house, like we are just roaming around as nomads, Lordship.
Residence.
No, we cannot stay. The next fact is that on 3rd May, after assurance of the police authorities, we went there to the residing to my house, Lordship. The police authority was there, Lordship. Again, after receiving the information, this private opposite party again with men and agents came there, and police authorities just watched the lawlessness, and they were again doing the same things, Lordship.
So
And again we had to
petitioner is
flee
unable
from
to
their
stay
Lordship.
at her own residence post election.
Yes, Your Lordship.
Your Lordship, this matter relates to the civil dispute, Your Lordship.
Civil
This is
dispute.
Provide protection.
Your Lordship, I have the
Take step
My
for,
only
which would permit the petitioner to stay at her own
Yes,
residence.
My Lord, I just need 1 day time. We have the
Why you are saying that it is civil dispute?
My Lord, I have the previous report. This is the old report because erstwhile we were appearing in this matter. Just now I received an
they
information
can
that no
never
advocate has
kindly
been
produce the
assigned
report then.
from the GP office and she is unable to attend the court today. She is having the report, Your Lordship. Just I need 1 day time.
Can I have the copy of it?
This is a previous
Oh, it
report.
is not been relied, Lordship.
Old
Not
report.
today.
Diploma.
Take back your affidavit, service.
Yes, Lordship. May it retain his position tomorrow, Lordship.
Next matter.
Item number 109.
Milord,
I am appearing for the respondent numbers 5 and 6. Let my learned friends conclude, then I will.
I'm for the state, Milord. This is the report, Milord. Milord has asked for report. This is the copy of the report.
দাদা আমি তোমার থেকেই দেখে নেবো তুমি মামলা করবে আমি জাস্ট অ্যাসিস্ট্যান্ট
It is a fight between you two.
my
We are,
fight is rising.
We are literally complying with the order of the law.
সার্টিফাইড কপি নেই
You were 6 and 7.
5 and 6 দাদা ডটার নয় বৌমা 6 বোধহয় বৌমা দাদা দেখে নাও মনে হচ্ছে বৌমা
Yes.
এটা হলো the bill পেলো। এই যে
Yes, whether the police authority has taken steps pursuant to this
Lord,
order.
they have gone. They have found that the premises is under lock and key. They were informed, my lord, that the premises has been transferred from respondent number 5, that is father, to her daughter, to his daughter, my lord, Ankita. So that report we have filed it.
But petitioner says it is her premises.
My lord, that
Transfer takes place.
my lord, that they can provide, my lord. What we have been told, we have put it on record. My lord.
Yes.
My lord, but we are being informed, my lord. We my lord have got my lord submitted it by a report that they said that the house belongs to the respondent number 5, and in the year 2023 he has gifted it to his daughter Ankita Das, who is not a party respondent here, my lord. And we went there, we found it under lock and key. We tried contacting Ankita Das, my lord. She did not catch hold of it. So, my lord,
we will make Ankita Das party.
My lord,
notice.
my lord, may I?
Why this was not brought to the notice of this court when this order was passed?
The order which your lordship had passed on 29/6/2026, wherein there was an erstwhile lawyer. This is a change brief to us. What we have gathered after sitting with this daughter, which my learned friend has spoken about, which your lordship desires to be added as a party, there are a lot of things which I also want to bring on record, for which I need to file an affidavit in opposition.
No, not at this.
Prior to your lordships, this writ, there's something very German. Prior to filing of this writ and movement of this writ, there was an
Please come
FIR
to page number 20, page 21.
21 of the writ petition.
Yes.
Yes, your lordship.
When this order was passed on 16 July 2024.
2024.
Yes. And this daughter of the OPs was present before the jurisdictional authority under 2007 Act.
Please present.
They also stated a petitioner that her daughters are barred from entering into the premises. OPs have committed by written statement that the petitioner can use all the electrical appliances. She will arrange a separate gas table for cooking purpose for her mother, and also arrange for installation of fridge point for her mother. They will take 1/4 responsibilities of their mother for a smooth livelihood. They also assured through commitment that their mother could freely move in the house without hampering their privacy. So this is the submission.
Before the SDPO. I bow down to what is falling from your lordship.
Yes.
I bow down to what is falling from your
Why
lordship.
this was not brought to the notice of the jurisdiction authority?
What I humbly submit.
When this gift deed was executed.
I understand what is falling from your lordship
When
and what is
this
happening.
gift deed was executed.
In 29th November 2023, much prior to this.
Yes,
much
how-
prior to this.
how this can be
I
done?
would state it, your lordship. I would state it.
And
There are
the petitioners filed Hajira so and so, and daughter of OPs is present.
present on behalf of OPs. Yes, she was present. She's a student of Jadavpur University. She was there. Now this gift deed which has
She didn't know at the relevant point of time.
no, she was aware.
That
She was
is the
aware.
owner of the property.
She was aware. She was aware. She has also filed a complaint wherein an anticipatory bail has been preferred by the writ petitioner.
I'm not
and there's a
concerned with
condition
this.
given. No.
What was the stand of the OPs before the jurisdictional magistrate?
Before the SDPO.
Forget about other things.
Before the SDPO, I was not the attending counsel.
That is
Kindly
not, that
understand.
is not the explanation.
OP had represented the parents.
You are not there. That is not the explanation.
The OP had represented
why
the lordship.
since you are representing OP,
Yes.
is asking why this was not brought to the notice of
Absolutely. I am giving that answer. I am giving that answer, lordship.
But I am not getting answer.
Kindly seize the first line.
Getting other issues.
No, kindly seize the first line which your lordship pointed out. Petitioner filed Hajira, daughter of OPs, is present on behalf of OPs. She had gone to represent the OP.
Break open the padlock and
My lord, at least gives me an opportunity to file an opposition because there are few things which are required to be brought on record.
Stage, I will not permit at this stage. If writ petition is admitted,
There was an appeal filed before against your lordship's order which has been withdrawn.
And relocate the petitioner there.
Your lordship would kindly gives me the liberty, the right of audio alteram partem. Your lordship knows at least
That will be considered.
because it's a change brief. I am appearing for the first time. Your lordship would give me the liberty to file an affidavit in opposition at least because these are matters of record.
By presenting this writ petition,
she had gone to represent the parents. She did not have her own case before this particular SDPO magistrate.
By presenting this writ petition, prayer is made for implementation of the order of the subdivisional officer dated 16 July 2024, which was passed in a proceeding.
Yeah, that is okay.
Under the maintenance and welfare of parents and senior citizens Act 2007. Next paragraph, taking note of this order dated 16 July 2024 after hearing petitioner, state respondents and respondent number 5 and 6. Court directed the police authorities to take the petitioner on a particular date to the premises and make arrangements so that petitioner can stay there in terms of the said order dated 16 July 2024. Stop. Next paragraph. Today, learned advocate representing state respondents has filed a communication, the undated communication.
My lord, it has been signed, my lord, and
Is a communication of inspector in charge, Siuri police station, Birbhum, and same is taken on record. Stop. Copies of said communication is made over to the are made over to the learned advocates representing petitioner and respondent number 5 and 6. Next, it is disclosed in the communication. that when police authorities or when police personnel went to the premises along with petitioner, it was found that the premises was under lock and key. So, as a result whereof, steps could not be taken for enabling the petitioner to stay at the premises in question. Next paragraph. Learned advocate representing respondent numbers 5 and 6 submits that their daughter is the present owner of premises by virtue of deed of gift executed by respondent numbers 5 and 6 both.
5. Your lordship 5.
Respondent number 5.
Part owner. She may be part owner because after the death of her husband, the petitioner husband, naturally all of them inherited. So he has transferred that part.
Respondent number 5. কি বললাম সেন্টেন্সটা? Next paragraph. Leave is granted to the learned advocate representing the petitioner to amend the cost title of this writ petition and array daughter of respondent number 5 as additional respondent in course of this day. In course of this day, you will be able you will share the details of your daughter.
She is in Jadavpur University. She is studying over
Share
there.
the details of your daughter so that
my
she can
junior
be
suite.
made party in course of this day. In course of this day. Stop. After such amendment is carried out, learned advocate for the petitioner is directed to communicate this order. Directed to serve copy of amended writ petition and order passed today upon additional respondent by 10 days from date and file affidavit of service on the next.
It will change correction error.
List the matter under the same heading for further consideration on. (26th August 2026). Come back. Let us.
Milord, in the meantime, we will break open and give her the access.
Wait for some time. Let the daughter be heard.
May I have the liberty to file a written opposition after he serves? After he arrays me as a party? After?
No, sorry.
Milord, only one. Only one thing. Your lordship need not open the brief anymore. As per your lordship's order, don't open the brief. On 29th of July, your lordship in paragraph 6 had mentioned in your lordship's order, your lordship's direction was to stay with the respondent numbers 5 and 6 where they are staying. That is just I brought to your lordship's notice because I understood the conduct of the daughter is not acceptable. Studying in Jadavpur University, she is supposed to be a very educated person, but she ought to have
and representative.
No, she ought to have represented before the SDPO regarding this. I bow down to that. As an officer of the court, I completely bow down to your lordship.
It is abuse of due process of law.
I completely bow down to your lordship, but your lordship understands. She's a student, she went. To be very honest with you, respondent number 5 and 6 ought to have given that.
Aspect, whether respondent number 5 is the owner of entire property.
No.
Not entire. What?
Then how
I have to come back with instructions.
The entire premises in favor of daughter.
I would come back with instructions and with document. And if he is owner, then the searching report of the property will show it.
If the property is under joint ownership of mother and respondent number 5.
Yes.
Then without
the consent and NOC of the mother.
Without partition being affected by meets and bounds. This
or subject to your lordship's discussion with an NOC of the mother.
This gift deed is void of an issue.
That they have a right under law for filing a suit under delivery up and cancellation of the gift deed.
This gift deed has no sanctity.
I bow down to your lordship. I will come down with a genuine searching report to show if it is a truth that it is a part owner, then this deed, I am telling with some authority as an officer of the court before your lordship, we do matters every day, then this gift deed cannot stand the test of law. But if the searching report says something else, the volume search done from that particular sub-registry, the district registry office, that the property belongs to the respondent number 5, then something else is also coming up before your
No,
lordship.
searching report is not sacrosanct.
I can give a certified copy that how my respondent number 5 is claiming as the absolute owner.
Searching report may be prepared based on deed execution of deed.
Yes.
But whether at all the donor
ownership
donor had the authority to
convey gift
or to convey this property
True.
in favor of the
Daughter.
in favor of her daughter when the property is a joint property.
Correct. If it is a joint.
Originally, my lord, the property belongs to Logendra Mondol. He died.
They later come.
My lord, 26 my lord probably is a holiday.
Yes, it's a holiday. It's a holiday. 26 টা বোধহয় holiday.
It's Fateh Doha's most probably.
Yes, your lordship. It's Fateh Doa's Dam.
In our calendar, it is not there because it is to be declared later.
As your lordship.
Let it be there, your lordship.
When it is declared holiday on the next date, it
27th. Deeply obliged. With your lordships.
Item number 110. My lord, I am for the petitioner, my lord. My lord, the last occasion, your lordships directed the learned advocate for the state to submit a report, my lord. And I was filed on supplementary affidavit, my lord, before your lordship.
I am for the respondent number 5 to 11, my lord.
দাঁড়াতে বলছেন সূর্য নীল নেই
Amen.
নাম দিয়ে দাও আমার
report.
Yes.
Any steps taken?
Yes, FIR has been already has been registered. FIR already has been registered.
Registered.
Cognizable offense has been found.
And FIR is registered.
No.
Why?
FIR not been registered because of the fact that the petitioner, 1 minute, my lord, kindly comes to page 2. Page 2, second last paragraph. The offense alleged in the complaint being the nature made punishable with the imprisonment for a term of 3 years, more or less less than 7 years. Attract the procedure of the 177(3) Bharatiya Nagarik Suraksha Samhita. That and subdivisional police officer Holdia subdivision and the consideration of the nature of the gravity of the allegations, a preliminary inquiry has been done. Police station to ascertain whether there exists a prima facie case of proceedings in the matter or not. Preliminary inquiry টা হয়েছে cognizable offense or petitioner did not turn out before the IU several occasions, twice. That is why FIR could not be registered. তিনটে নাম দিয়েছে?
Petitioner is not cooperating.
Yes.
My lord, I went to the police station, my lord, your lordship, kindly. My lord, my
And the police authority is saying that if ultimately petitioner cooperates and appears before the police authority and
my lord, I have
Can
filed a
only
supplement.
point-
hear this court.
My lord,
Can be
my lord, my lord.
Offense is alleged to have been omitted. In that event, FIR would be raised.
Yes.
Still, it is at the preliminary inquiry stage.
My lord, your
So
lordship.
therefore, to advance the preliminary inquiry, petitioner needs to appear. It is stated that to that end that the petitioner has been called upon by the police authorities on repeated occasions, including by notices dated 16 June and 21st June,
Yes.
which were duly acknowledged by the petitioner's relative, namely so-and-so, and a copy of the notice was also affixed on the wall of the residence of at Devog under police station Bhavanipur. Despite the same, the petitioner has neither appeared before the neither appeared before nor responded to this police station till date.
My lord, your lordship, kindly, I filed a supplementary affidavit. I've stated that I went to the police station and my lord, they are also called, private respondent was also called. But during that,
This is not a forum for seeking a direction in order to get your complaint registered
my lord,
and commencement of criminal
my lord,
prosecution.
my lord.
Appropriate forum is the jurisdiction magistrate under section 175(3).
My lord.
Therefore, if these things go on, then I will not permit this writ petition to be kept pending for independent.
My lord, your lordship, kindly hear me, my lord.
Police is saying you did not appear. You are saying no.
My lord, on
notice
oath
was
I have
given.
stated, my lord. On oath I have stated, my
My
lord.
kindly-
Your lordship, kindly see page 4, my lord. I have
So,
Well, whether writ petition is maintained.
pursuant to the order dated
my lord,
23rd of
we
July
have a copy of the
2026,
report, my lord.
pursuant to the order dated 24th of June 2026, a report dated 8 July 2026 is presented before this court. A report dated a report dated 8 July 2026 of officer in charge Bhavanipur Police Station, Purbo, and the report is presented before this court and same is taken on record. Next paragraph, it is disclosed in the report that till date FIR is not registered since petitioner is not appearing before the concerned police authorities pursuant to the notices issued. Stop. Next paragraph. If petitioner finds that FIR based on complaint lodged by the petitioner is not registered, in that event petitioner needs to approach jurisdictional magistrate under section 175(3) BNSS 2023. Writ court is not an appropriate forum to ventilate grievance in the event FIR is not registered. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2007-6 SCC 171, Aliu Padamsi and others versus Union of India and others. Next paragraph, hence present writ petition is not entertained. Hence present writ petition is disposed of with liberty to the petitioner to approach jurisdictional magistrate under section 175(3) BNSS 2023. Stop. Urgent xerox of that complete. No use of keeping this matter pending. Is not a fact-finding court whether at all notice was issued. And if notice was issued, petitioner did not respond. It's not a fact-finding.
There is also a false and frivolous statement in the writ
Very well.
petition.
Later take steps in accordance with law.
Item number 111. I am on behalf of the private respondent number 6 and 7.
My lord. The matter was taken up by my lord on 22nd of June 2026. It's the mother who has been thrown out from the property. Entire money, literally, he has to.
Report.
Yes. Twice they were called and notice was served upon them, but they did not turn.
Petitioner.
She came down to Purulia with police from. She was staying, came down from Purulia. She stayed over there.
As per my report, this is the fact.
It was informed to the police, notices were served. She came down to Purulia from Purulia. The notice was served at Purulia. The copy of the notice is with me, my lord.
Second page. Second page, second paragraph, my lord.
What is your case?
My lord, the mother was, the entire money which was lying joint account of the father, the petitioner's husband and the petitioner were owners. The petitioner's husband was the owner of the property, my lord. She was staying with the husband expired. The entire money of 62 lakhs after the demise of the father, after the demise of the husband of the petitioner, the son approached that you have become aged, let us maintain the, I would maintain the bank accounts. Entire money has been siphoned out. The bank accounts are the
money was siphoned out
by the son. The statements are also annexed, which has been transferred in the account of the daughter-in-law. After taking off the, she asked for the money, some money for her maintenance. She was thrown out from the property. She has to live with her son-in-law in Purulia. Thereafter, the writ petition was filed. My lord's intervention. She came back. Notices were served to the petition. Notices were served. She came back. And the farm.
How the money was siphoned off?
My lord,
if it was lying in your name?
It was a joint account, my lord. The accounts were, that is to be verified by my lord. Or
then if it is a joint account
of the husband.
Joint account, then the son of the petitioner is authorized to operate the account.
Joint account of the husband and the petitioner, my lord. After demise,
then the son was inducted.
The son came back, the respondent number 6, asked to sign some forms. The petitioner has no knowledge why, and
without your signature, son cannot be inducted as a joint account holder.
That's the fact. She had signed some documents, but thereafter.
Then where is the wrong? Where is the criminality in it?
My lord, there's criminality. After that,
X and Y, both are joint account holders.
X
in connection with the bank account. Then both are equally authorized to operate the bank account. He has operated the bank account and taken the money.
Operated the bank account.
What can be done?
Initially, the bank accounts were in the name. If my lord takes up annexes once my annexes, my lord, the bank statements, my lord. At page.
Now, FIR is already registered.
FIR.
So let the investigation be carried on.
And she may be allowed to stay with dignity in the house, my lord, in the
Police tried.
Srirampur.
Police tried, but she did
Petitioner
not
did
turn
not
up.
appear.
Did not turn up.
She appeared. She appeared. I have instructions. She appeared. She was staying with there.
Police is
Thereafter,
ready
again,
to
the
provide
same
assistance. Police is ready to provide assistance
She
for your
approached
entrance in
police.
the house.
Second complaint was
But
also
unless you appear, what to do?
My lord, on 7th of August, he has to lodge another complaint through email. If my lord takes up the photocopy of the email once, but she has been thrown out from the property. She has again gone to Purulia, staying at her son-in-law's house, my lord.
Issue.
Ask her to come. Police is ready to provide assistance.
Matter is heard in presence of the learned advocates representing the petitioner, state respondents, and respondent number 6 and 7. Next paragraph. It is alleged by the petitioner, being mother of respondent number 6.
6 and 7, son and daughter.
7 is daughter-in-law.
Daughter-in-law.
6 is son.
Son.
It is alleged by the petitioner, being mother of respondent number 6, that respondent number 6 has withdrawn money from account of the petitioner, from joint account of petitioner and respondent number 6.
Yes, not respondent number. So it was the joint account of the petitioner and her husband, my lord.
Subsequently, respondent number 6 was deducted.
That has to be investigated whether his name.
No, has withdrawn money from bank account of the petitioner illegally.
In the year 2021, my lord.
And same was transmitted to the account of petitioner's daughter-in-law, being respondent number 7. Stop. It is also contended that petitioner has withdrawn the withdrew. No, has withdrew. Right. It is also contended that petitioner is not being permitted to stay at her residence, where respondent number 6 and 7 are residing. So prayer is made for giving direction upon the concerned police authorities, which would permit the petitioner to stay at her own residence at Srirampur.
Boidobati Srirampur.
At Srirampur.
বৈদ্যবাটি না শেওড়াফুলি কোথায়? শেওড়াফুলি না?
At Srirampur.
হ্যাঁ, বৈদ্যবাটি বলছি তো। বৈদ্যবাটি। My lord, it is not Srirampur, বৈদ্যবাটি.
It is under the jurisdiction of
Srirampur PS. Srirampur PS.
Stop. Next paragraph, in terms of previous direction, dated, in terms of previous order dated 22nd June 2026, a communication dated 1st July 2026 of Inspector in Charge, Srirampur Police Station is filed today and same is taken on record. Copy of the communication dated 1st July 2026 copies are made over to the learned advocates representing the petitioner and respondent number 6 and 7. Next slide. Learned advocate, Mr. Chakraborty, learned advocate representing state respondent, submits on instruction that in spite of arrangement made to take the petitioner to her residence at Srirampur, petitioner did not turn up. Stop. Next paragraph. From the documents, from the report filed today, or from the communication dated 1st July 2026 filed today, it appears on registering FIR, a criminal prosecution being Srirampur station case number 343 slash 26 dated 24 June 2026 has been initiated against respondent number 6 and 7.
6 and 7.
Against respondent number 6.
6 and 7.
Based on
both, my
6 and 7.
both.
Based on complaint of the petitioner. Concerned police authorities are directed to take, next paragraph, concerned police authorities are directed to take expeditious steps to take the criminal prosecution to its logical conclusion by submitting report before the jurisdictional magistrate. Next paragraph, it is if it is found that petitioner is owner of the if petitioner is owner or joint owner of the premises at Sirampur, Hooghly, and if petitioner appears before the police authorities, thereby expressing his willingness to stay at the premises, in that event, concerned police authorities shall take steps which would enable the petitioner to stay at the said premises. Stop. Next paragraph, with the aforesaid observations, writ petition stands disposed of. Parties to act on the server copy.
Item number 112.
Milord, I am for the petitioner. Milord, the petitioner hold the ancestral property, and there was partition suit was pending and one title suit is pending, and both the suit there was injunction. But in spite of the said private respondent, as the elder brother of the petitioner died, forcefully giving the wall and dividing the said property. Milord, violating the said injunction order of status quo, Milord. We have approached to the civil court in such violation, but they have stopped our egress and ingress and other property and cut the tree from our part, Milord.
You have approached civil court.
Yes, Milord.
Where is the order of the civil court?
Milord, I have annexed the injunction order.
Page.
Milord, marking I can. Milord,
give your brief to him. Mr. Das, give your brief.
One complaint was lodged, my lord, to the officer in charge, my lord, concerned police station, my lord.
Milord, page number 17, the injunction order was communicated.
Where is the order?
Milord, order has been.
Where is the order?
Milord, order has not.
Passed by civil court. Advocates communication court will not believe.
Milord, order has not been. The partition suit has.
Then what you are praying for?
Milord, for our protection. Our trees has been cut away.
Reserve your right over the property in question.
Yes, Milord.
And not to encroach your property.
Yes, Milord.
And not to enjoy usufruct of the property. Now, if this is your case, then you have to approach the civil court.
Yes, Milord, we have already, Milord, kindly.
Approach the civil court, what police authority will do?
Milord,
because it's a dispute,
Milord,
it is a private dispute between two parties.
Yes, Milord.
The police authority
No,
will
no,
decide
Milord.
whether the property belongs to petitioner or private respondents.
Milord, it is an ancestral property, Milord.
What is your submission, Mr. Das?
Mr. Das, petitioner tries to grab my property, my lord.
How?
That's why, my lord, I have filed the.
Milord, kindly.
Saying that it is his property.
Milord, it is ancestral property. Milord, I am reading. আত্র আদালতে এলাকাধীন হিঙ্গলগঞ্জ চন্দরগত সিধরি কোটা
private respondent Ashit Mondal, the private respondent number 5, Ashit Mondal, he has lodged an FIR against the petitioner and other co-sharers involving there is a forgery. They have done a forgery in the deed.
Milord, all
anticipatory
pending.
bail has been.
FIR is pending.
FIR is
Uh,
pending.
K-
The investigation
FIR is registered.
registered and the investigation is pending.
You are
on that
representing
petition.
respondent number 5.
Respondent 5.
And there is
My
also
lord, kindly see
FIR
page number
lodged against
10,
the-
my lord.
Tries to grab my
Yes,
property.
allow her to make submission. There is
and
also
there is
FIR.
a counter case lodged against the respondent number 5 by one Nandita Mondal,
He is also a
who is also
co-sharer.
co-sharer.
And FIR is also registered.
FIR is
So
registered.
case counter.
Case.
And in
To that extent, no prayer is made in this writ petition.
Not made in this writ petition. My lord, the petitioner is Kakuli Mondo. She is also one of the co-sharer, and she has been arraigned as an accused person in the FIR registered by the respondent number 5.
But I need not enter into this
Lordship,
case and counter case based on
This is-
registration of FIR. That
Lordship.
is not the subject matter. Come to the prayer, page
That
7.
is the protection and
my lord,
Protect the property of
the petitioner.
issue. Matter is heard in presence of the learned advocates representing the petitioner, state respondents, and respondent number 5. Next paragraph. It is contended on behalf of petitioner that direction may be passed upon the concerned police authorities to take steps in order to protect property of the petitioner from encroachment. Stop. It is also submitted that respondent number 5 is trying to encroach the property of the petitioner. Next paragraph. A learned advocate representing respondent number 5 submits that learned advocate representing respondent number 5 disputes submission made on behalf of petitioner, and it is contended that the property in question belongs to respondent number 5, and petitioner is trying to grab the property. That is your contention?
Yes, ma'am. Yes, ma'am.
Next,
it is an ancestral property, my lord.
state respondents are represented by learned advocate, and it is submitted on instruction that two parallel criminal prosecutions are pending against two other parties interested in the property in question. However, no criminal prosecution is pending against the petitioner or respondent number 5.
Yes, my lord.
My lord, respondent number 5 has the petitioner has been arraigned as an accused person in the FIR registered by the respondent number 5. But the complaint lodged by the petitioner that has not been registered as an FIR. But
so one person interested in the property has filed an FIR, lodged an FIR against the petitioner.
Against the petitioner.
And the criminal prosecution has
Initiated.
And the counter FIR?
Counter FIR is the respondent number 5 is the party, lodged by one of the co-sharers.
So there is another FIR against respondent number 5.
Respondent number 5.
That has and based on which FIR is registered.
The FIR has been registered, but not by the petitioner.
So both the parties, and
co-sharer.
respondent number 5 are accused persons in two prosecution.
I have also.
What prosecution? And petitioner is the accused person in one prosecution.
My lord, I have also filed.
In one prosecution, petitioner, and in another prosecution, respondent number 5.
My lord,
Yes, my lord.
my lord,
Yes.
I have also filed the suit for declaration, my lord. An injunction is there, my lord.
Yes, injunction is there. It is admitted, my lord.
Allow this court to dictate order. Yes. One against the petitioner and another against respondent number 5. One against petitioner and another against respondent number 5. However, next paragraph. However, considering the case made out in this petition, it appears that this court is not required to enter into the criminal prosecution. Is not required to enter into the criminal prosecutions initiated against the petitioner and respondent number 5 based on complaints lodged. Rather, it transpires that by presenting this petition, petitioner has made an attempt to protect his property from to protect the property in question from in his court, to protect the property in question from encroachment. Stop. Claim is laid on behalf of respondent number 5 over the same property. Next paragraph. Therefore, issue involved in this writ petition is civil in nature, requiring the petitioner to approach appropriate forum in pursuit of remedy. Police authority is not the appropriate authority to decide inter se right of the parties over the property. Next paragraph. Hence, present writ petition is not interfered with and same stands dismissed. However, this order shall not preclude the petitioner to approach appropriate forum in pursuit of remedy.
Right. নামটা দিন।
Item number 113.
113, Lordship.
Lordship, I am for the
state-
petition. I'm praying for not this week, my lord.
Lordship, the number of FIRs, particulars of the FIR. Who's it?
Yes, particulars of FIRs.
Yes, Lordship. 2 other FIRs has been lodged.
These are the proceedings which are pending against the petitioner.
Yes.
There are no other.
No other FIRs apart from this.
Issue. A matter is taken up for consideration in terms of order dated 23rd June 2026, when Ms. Suchitra Shina Chatterjee, learned advocate representing state respondents, has filed a report dated 3rd July 2026 of Director General and Inspector General of Police West Bengal, and same is taken on record. Stop. Copy of the report dated 3rd July 2026 is made over to the learned advocate representing petitioner. Next paragraph. In view of disclosure of criminal prosecutions pending against the petitioner, no further order need be passed on this writ petition. Now, in view of prosecutions pending against the petitioner by video report dated 3rd July 2026, no further order need be passed on this writ petition, and the writ petition is disposed of. Parties to act on the server copy.
Grateful.
Next. Give a copy to her.
Yes, Lordship. I have
Report of
already-
DGIG.
I have already served her.
Item number 114.
My lord, I appear on behalf of the private
No, I am for
respondent.
the petitioner. No, I have taken instruction. The grievance of the petitioner has been replaced.
Yes, grievance is replaced.
FIR has been registered.
FIR registered.
I have taken instruction.
On the last occasion, there was a direction upon the state to file a report.
You want report? At the time of call, learned advocate representing petitioner submits that grievance of the petitioner is redressed. Stop. Respond. You are which respondent number?
Both the private respondents.
Number.
Number 4 and 5.
Respondent numbers 4 and 5 are represented by learned advocate. Next part. In view of such submission made on behalf of petitioner, no further order need be passed on this writ petition, and the writ petition is disposed of. Parties to act on server copy.
Grateful error.
এই পেন্সিলটাকে তুলো না। না এখন পারবে না, ছেড়ে দাও। পরে তুলি।
Item number 115. I am for the petitioner, my lord.
Stated.
My lord, state was supposed to file a report. Sir.
Misstated.
Hey,
My lord, I'm appearing for
Well,
private respondents.
In the meantime, my lord, the stolen goods have been seized. Recovered, my lord.
Your grievance is redressed.
Yes, my lord. It has been given to our Jimma.
Investigation is going on.
Learned advocate representation.
My lord,
And
my lord, one thing, my lord, police has submitted the FRT, my lord. We have, My lord, we have got the certified copy. This is specifically FRMF, that's mistaken facts.
Yes, mistaken facts.
Yeah, my lord.
My lord, I'll file an exception to this report because my lord, the stolen goods have been recovered. My lord, will kindly record my submission that I'll file a, I may be
No,
allowed the liberty to
stolen, it is his writ petition.
Yes, ma'am.
He is submitting that stolen goods are recovered and his grievance is redressed. Now, if petitioner is dissatisfied with FRT filed before the jurisdictional magistrate, he has a remedy under section 193(9). So this court is not required to enter into that arena.
Absolutely.
At the time, learned advocate representing the petitioner submits on instruction that stolen goods are recovered and a seizure list is prepared by the investigating agency. Stop. According to the petitioner, grievance of the petitioner, according to the petitioner, his grievance is redressed.
And I have a
Stop.
report to this extent.
Stop. Next paragraph, learned advocate representing state respondents, thou reporter. Learned advocate representing the state respondents has filed a report. Dated 5th July 2026 of officer in charge Gurap police station, Hooghly, and same is taken on record. Next paragraph. Respondent number you are representing?
6 to 8.
Respondent number 6 to 8 are represented by learned advocate who has submitted that that the final report was filed before before jurisdictional magistrate on completing investigation. Stop. Next paragraph. Since it is contended on behalf of petitioner that his grievance is redressed on recovery of goods, no further order need be passed on this petition and same stands and same is disposed of. Parties to act on the server.
Grateful, madam.
Item number 116.
116, my lord, I am for the petitioner. My lord, the petitioner before your lordship is a local leader of the erstwhile, my lord, ruling party, my lord. And my lord, he was ousted from his house from 4th May 2026. He had 3 security guard that time. Now, my lord, his house was ransacked the day of result of the election, page 18, my lord. Two-fold prayer, my lord. One protection and another criminal case. How many cases pending?
Why we are seeking protection?
The protection, my lord, from 4th May 2026.
We are in the month of August.
No, nothing.
Water has flown
Yes, no, my lord. Till now, my lord, he is out of, my lord, residence, my lord. Till today, my lord. My
He is
instruction,
out of residence.
my lord. And not only that, if your lordship have a look into that, my lord, in the how the house was ransacked by the, my lord, hooligans of the.
Why your house is ransacked?
At
Others
that time,
are not.
my lord, that time the petitioner is a.
Well, come tomorrow. Not today. Let it retain its speech.
ভালো করে রাখ।